Before the court with his counsel, Mr. Shapiro, Mr. Cochran, Mr. Blazer, Mr. Neufeld, Mr. Scheck. People represented by Ms. Clark, Mr. Darden, Mr. Yokelson, and Mr. Harmon. The jury is not present. First order of business, counsel, I scheduled the hearing on the prosecution's motion to admit certain testimony concerning the defendant's activities, I guess is what we would call it, on June the 17th. That hearing was set for 8:30 this morning. Court was here, defense counsel were here, defendant was here, and we were ready to proceed. The prosecution did not choose to appear in court until 9 o'clock. Is there an explanation for this?
Yes, Your Honor. The person designated to argue this segment of the case had an emergency at home and was unable to make it, and I apologize to the court. But the time has not been wasted. I have been in conference with other members of the team. At this time, Your Honor, we'd like to indicate to the court that we will not be asking to admit the events of June the 17th at this time. However, I repeat at this time because we have not yet heard the end of the defense case. We have not yet heard Sir rebuttal, and I would like to reserve the option of asking to renew our request to admit that evidence depending on what we see in the balance of the defense case in chief and Sir rebuttal.
All right.
We are trimming this case so that we can get it to the jury, and we are hopeful that we can rest the people's rebuttal case tomorrow.
All right, Mr. Cochran, as to the withdrawal of the June 17th witnesses.
Yes, well, we certainly accept that withdrawal. We think it's appropriate, saves you having to waste your time on that. And we accept that, obviously, Your Honor, no problem. I'd like to raise a couple of issues if I might, Your Honor.
All right, well, we're not finished with that yet.
Okay, certainly.
All right. The offer is accepted. However, the failure to appear in court in a timely manner and failure to advise the court, sanction will be $250 to the district attorney's office. That's to be paid by the close of business today. I'm more annoyed.
May I remind the court that Mr. Shapiro kept the court waiting for 20 minutes, showing up at 20 after 9 when it was his witness on the stand and suffered no sanction?
Thank
Sure.
you. Sanction will be $1,000.
How much?
1,000.
Oh.
Next
Your
question.
Honor. Fine. May I proceed, Your Honor, now? Your Honor, with regard to, at the end of the day yesterday, Your Honor asked us not to waste your time. Ms. Clark, on the record, indicated certain witnesses. You'll recall she said people like the modified Thanoparatus video, which you talked about, and the Diedrich and Bodziak and the Bronco fiber issue and the Accards and all those kind of things. And you said, don't waste my time, get together. Mr. Douglas went over and talked to Mr. Darden, who told him, I don't know who we're going to call. They gave us no proffer, no offer of proof, no cooperation, no nothing. So we don't want to waste your time, Judge, but when they won't talk to Mr. Douglas, what are we going to do? So the problem is, and they said they don't know who they're calling. If, Judge, they are saying they're going to finish this case by Thursday or by Friday, then we're entitled to all the rest of their witnesses. We're entitled to the end of the witnesses. And all we're trying to do is get somebody to talk to us so we can resolve this matter. We want to resolve it. If they really want to get this case to the jury, we'd like our proffers. We'd like to know who they're really going to call. Now the 17th is now out, and that's fine. And so we'd just like to have, would you direct them to meet with Mr. Douglas right now so we can get this done, Your Honor?
I met with Mr. Douglas. Good morning, Your Honor. I met with Mr. Douglas yesterday afternoon. I gave him approximately 6 names that included Sims, Diedrich, Bodziak, Lawrence Acker, Nancy Acker. What other names did I give you, Mr. Douglas? I don't know what he's talking about. I've given him the names.
No. And Mr. Douglas can speak
I
for
gave him the
himself.
names. If Mr. Douglas says that that isn't correct, he was writing on his pad. I was standing right here yesterday late afternoon. If that isn't true, is that true?
I asked him what order is going to be called following Sims. Mr. Darden said, I do not know. I asked him this morning. He gave me these names. I asked, what order, who's next after Sims? This morning, he said, I do not know. If I'm mistaken, please correct me.
Right. But he gave you the witnesses. He's given you 5 or 6 names, correct?
He did, Your Honor. And I asked who follows Sims so that I can have the person who does that witness ready after Sims.
So, in other words, Your Honor, what we're saying is she gave us some names in court, but we want to know who's up next, what's the offer of proof.
They've given you the names. We know who Bodziak is. We know who Sims is. We know who Diedrich is.
I can tell you this about the Ackers. We're trying to get the Ackers here from out of the country to testify tomorrow, so they won't be here today.
All right. Testify as to what?
Hydra issues.
Heidstra, okay.
Your Honor.
And they have the discovery on that.
All right, Your Honor, and may I inquire, are they still planning to rest then by tomorrow or Friday? Because then we would be entitled to anybody else they have. Within the 3 days, and we're just trying to find out who
Well, I
else they
assume
have.
that's their case. They tell me that they're going to rest tomorrow or Friday.
All right, that's fine then, Your Honor. The last thing is, Your Honor, the next thing I'd like to, we're going to have to address at some point this Bronco fiber issue, which we think shouldn't take the court very long, speaking of no-brainers, but we're ready to do that whenever you want to. The last thing is, we would like to have Agent Martz, FBI Agent Martz, back here, need this court's assistance for, if they're going to rest truly on Thursday or Friday, for our case on Monday, September 18th. We'd like to request that now, so we'll have him here. In addition to that, we expect to call Special Agent Whitehurst of the FBI, and we expect that hopefully Mr. Scheck has started a procedure by which hopefully justice will make this person available. He's a critical witness in this case, and it'll tie in with the March testimony, so that there's no delay in that regard.
All right, if there are any interstate subpoenas that need to be issued, submit them to Mrs. Robertson
All right.
as soon as you can.
Thank you. May I have 1 second? Your Honor, so we're trying to save downtime. We will work on that today. The last thing is, Your Honor, on this whole issue, if the Ackards or anyone's call with regard to Robert Heistra's testimony, we need Detective Dennis Payne, who we understand is retired, and we want to put him on notice now. We need Payne if he's out of...
Is Payne the one who took the
Yes, he took
statement
the statement.
from the Ackards?
From Heistra. No, from Heistra.
From Heidstra.
Heistra. And we need
Okay.
him right away, so we need your help, and we want to put him on notice. We want Payne, so there'll be no downtime on that as soon as possible. Might as well have him here Monday.
They should contact the LAPD. At any event, they marked Mr. Heistra's statement. I'm not sure, but I think you admitted it in the evidence.
We want Dennis Payne, you know.
Okay. Well,
So that's the issue on that.
they
All right.
call the LAPD.
Then you're not willing to make him available?
He's retired, Judge. I can't make him available.
All right, you'll have to subpoena him.
You get an address or something, Your Honor?
Penal Code section that would preclude us from giving them the address of the retired police officer.
All right, well, counsel, what we'll do is, I don't care about this fight between the parties. I'll have my staff contact the LAPD and make them
Thank you, Your Honor. That's
get
all
their
we're
cooperation to produce it.
asking. And producing for Monday, Your Honor. Thank you very
Well,
kindly. Or as soon thereafter.
he's retired, he could be in Florida, who knows?
Well, we'll try to, as with the other witnesses, we don't want to let this trial, we pay for him to come back.
All right,
Your Honor, with respect to Agent Diedrich, if I understand it correctly, he's supposed to be here, arriving here at 12:30, the last representation, and Mr. Morton is going to be able to get here at 12:30, 1 o'clock. I at least would like the opportunity to look at the underlying data from the report that they just gave us. I do get that
I issued that
opportunity.
order yesterday.
I understand
They're
that.
As soon as the exemplars or the impressions are here, you're entitled to look at them, to see them. You're entitled access to that we dealt with that issue yesterday.
No, I understand that, but just wanted to make clear we're going to get that opportunity, and that includes the jeans, the envelope, the shirt.
The whole enchilada.
Well, all right.
All right.
I just want to put, in terms of scheduling, I want to put the court on notice, and
All right,
Your Honor, we need to, number one, we need to be heard with respect to the admissibility of the Whitehurst issue. And we're prepared to argue that so that we do not waste time trying to locate a witness who I believe has testimony that has nothing to do with this case and is irrelevant. So, we're going to go into downtime to make him available when he has no admissible evidence. Secondly, I'd like to argue the Bronco fiber motion.
well, let's do this. Let's proceed with your next witness this morning with the jury, because the jury's expecting testimony now. As soon as we complete that phase of your presentation, where do you anticipate going after that?
Well, we had wanted to go with the Ackards since they're not available immediately. I would like to, we may have a little downtime because we have to fly witnesses in. The Paratus tape presented with the testimony of Steve Oppler, and we have, which we've edited and will show to the court. And Then we would intend to call Doug Diedrich, any fiber witnesses that we're allowed to call, and Bill Bosiak. But they won't be ready for testimony until tomorrow morning. So we might have...
All right, so then the point of my asking you that question is that we don't need to resolve that issue now. If there's going to be downtime for witnesses, we can use that time to argue the motion.
Well, the problem is I don't know whether to notify the witnesses to come in or not until the court rules.
Where are these witnesses coming from?
Washington, I believe. They're fine. They're not in the state. No.
Okay.
And I didn't want to fly them out if the court was going to... I mean, they're on standby. I have them on call, but I'm not going to spend the money to have them out unless you stay.
All right. Mr. Cochran, who on your side is going to argue the Bronco Fiber motion?
I believe it'll be Mr. Blazer.
All right, are you prepared?
Yes.
All right, I'll hear the argument.
I believe we're the moving party, Ron.
Yes. I just wondering who was, if they were ready, you're ready?
I'm ready. They're ready. As my moving papers have indicated to the court, we believe that the evidence is admissible and proper rebuttal for two reasons. First of which is, I believe we appended to our motion the transcript sections from the testimony of Kathleen Bell as elicited by Mr. Bailey, in which he gratuitously asked her questions concerning the kind of car Mark Furman drove, or she believed he drove, back when the statements were made. There was no purpose, no legitimate purpose for asking that question unless it was to, other than the one we're arguing they were trying to infer, unless it was to show that she in fact did know him and therefore could identify him. That argument, however, falls as specious because there was never an effort to link up the car she described to any car known to be driven or owned by Mark Furman, which could have been done through DMV records or any other people who knew him at the time, including the police department. No such effort was made, and it is clear that the motivation for asking those questions and eliciting not once but twice that she saw him driving a sports utility vehicle was to have the jury infer that he preferred that kind of vehicle and therefore the fibers could have come from that vehicle. And as the court recalls, Mr. Bailey was the one who handled the hair and fiber evidence with us and is most acquainted with the issues concerning the admissibility of the Bronco fiber study that was conducted by Agent Diedrich. That's on one hand. Secondly, with respect to the attack on Mark Furman's credibility, as the court is aware, an all-out attack was launched on his credibility and has become the cornerstone of the defense case. Anything in the case in terms of scientific or objective evidence that tends to indicate that the glove was not planted and that he was not responsible for the planting is naturally relevant as a rebuttal to that claim. Having found Bronco fibers on the Rockingham glove, and that's key. It's not the Bundy glove, it's the Rockingham glove, and that's the one they're claiming was moved. That is key to establish that, in fact, it was not planted because the fiber on that glove came from a rather unique source, not just any car, which is what otherwise they could argue, or even any carpet in a house, but a very unique fiber that was made during 92 up and 93 and put into 94 vehicles, a fiber whose configuration in terms of the cross-section and the dye formulation was changed later in 94 and had not been made prior to 92. Moreover, this is a fiber in which carpeting was used for only three kinds of cars, predominantly for the Bronco, more secondarily in much fewer number, Econoline vans and F-Series trucks. So you have very highly probative evidence found on the glove that could not have been planted that would tend to rebut the claim that the glove was planted by Detective Furman. So we have two independent bases on which to admit this evidence now, which makes it proper rebuttal. People have cited the cases to the court that indicate why this is admissible rebuttal and why it is proper to address this at this time. The court is aware, of course, that the discovery has been given to the defense on this, so there's no element of surprise here. The witnesses that would be called to prove this evidence would be two at maximum, three in number of very short duration. One, to talk about the fact that the fiber of this cross-section was made during these years, sold to Masland. Masland representative will say that fiber was put during these years with this dye formulation into these cars. And that's it. And then Doug Diedrich to say, and that's the fiber I saw. That testimony collectively for all three witnesses should not take an hour. So we are not talking about an undue consumption of time either, but I do think it is highly probative and certainly important to rebut the claim of any evidence movement by the defense, especially the Rockingham glove.
Mr. Blazier?
Good morning, Your Honor. As the court will recall, I believe it was with Susan Brockbank, I asked a series of questions about whether they had checked other vehicles, and I asked those questions based on representations that had been made to us by the manufacturer of this fiber that it was very, very common. Unbeknownst to me, that same person, the actual person that we had talked to, had already provided written documentation to the FBI as part of their investigation of the source of the fiber that they titled it. That was just completely the opposite. And it was only after that point that Mr. Dietrich came in and brought his paperwork. I asked him a number of questions before he testified to try and find out what he had, and he was very, very evasive. Finally, the court had to intervene and make him have a copy of his whole binder made. And in that binder is this very, very detailed report where they had done a thorough investigation months before. I think it was a 7- or 8-page report titled "The Source of the Fiber." And the court, properly so in our view, precluded the prosecution because of misconduct from putting on any of that evidence because it had been held back and not turned over in a timely fashion prior to our conducting our cross-examination of these witnesses. We were extremely careful after that point to not ask a single question about rarity of Bronco fibers. We didn't ask anybody about that because we did not want to open the door. Now, as I understand the argument, well, first of all, I think it's interesting that Ms. Clark has argued many, many times that there's absolutely no evidence that Detective Furman planted the glove. Now she feels the need to bring this evidence in to show that Mark Furman's carpet fiber is not on the glove. We have never said that. We've never maintained that. The references to his green utility vehicle it was obvious what the purpose of that was. It was to demonstrate that Miss Bell recognized his car and had seen that same car with him in it on a couple of other occasions. If the prosecution is concerned that we would argue that the car that Mark Furman drove in 1986 might have a fiber that matched the fiber on the glove, they can put on a witness to say what kind of fiber was in Mark Furman's vehicle. That would certainly solve that problem. That's not the reason they want to do this. They want to do this because they think that was powerful evidence. It was precluded before because of their misconduct, and now they're trying to find a way to get it in. This is just a ridiculous argument. And we haven't offered any testimony about what vehicle Mark Furman drives. We don't intend to. We would never argue that. That's a ludicrous inference. It's not believable. It's not a justification for putting on this evidence that was wrongfully withheld before.
What do you think about a restriction if I maintain the preclusion, a restriction on argument as to the rarity of the fiber and the lack of evidence thereof?
Well, if they're allowed to put on evidence about the rarity of the fiber, then the preclusion, the effect of the preclusion is nil. I mean,
No, you misunderstood my comment. If I maintain the preclusion, that's likely to include a preclusion of argument.
Oh, absolutely. That's no problem. We don't intend to argue that.
Maybe just a second, Your Honor.
Stated in the record, I assume, is what you mean.
That's fine.
We don't have any problem. We're not going to make any argument that we know is misleading based on information they've obtained. I have no problem with that. I assume that's what you were suggesting.
I'm just asking.
Yeah, that's fine. We didn't plan on arguing that anyway. We don't want to do anything improper in closing that might allow them to come back and ask to have the case reopened. That would be foolish.
All right, thank you. Ms. Clark.
I don't know why they're trying to hide the truth. Doesn't the jury have the right to the very best evidence that exists? We have evidence that is very powerful, that is further evidence of the defendant's guilt, and to simply preclude them from arguing that it was Mark Furman's vehicle does not go anywhere near addressing that issue. Furthermore, if there is to be a preclusion in the alternative, Your Honor, then the preclusion should include their ability to argue that any police officer's car could have imparted those fibers, because that is in fact the case, and that would in fact be the testimony.
I accept that. I mean, I assumed that what you were referring to, we would not make the argument that it could have been in any police car. We would not make that argument.
All right. Thank you,
think-
counsel.
Your Honor, I just think the rarity of the fiber is very probative evidence for the jury of the defendant's guilt. And I think that given the nature of the attack in this case and the arguments about planting of evidence, it becomes even more probative. And I think it's evidence that the jury should hear.
All right. Thank you, counsel. The reason for the court's initial preclusion was the failure to disclose the report, which gave indicia of extensive investigation as to the source, nature, and rarity of that particular fiber. That information was not turned over during the course of discovery as required. The court felt that preclusion at that time was the appropriate sanction. The proffer at this time is that Kathleen Bell testified that she observed a pea green utility vehicle at the Marine recruiting station at a time that coincided with Detective Furman's presence at that location. She then testified that she saw Detective Furman in a business establishment in that same general area, and that on another occasion also saw the same pea green utility vehicle at that location and chose not to enter the location, fearing that Detective Furman was again there and not wanting to reacquaint herself with him at that time, given the nature of her testimony. These events occurred in 1986. There was no contemporaneous testimony indicating that Detective Furman had any contact with the same vehicle. The testimony was that Detective Furman drove to the Bundy location in a police vehicle with Detective Phillips. The proffer has no probative value, and the court's previous ruling stands. All right. Let's call our next witness.
Your Honor, just one quick.
Yes.
All I ask is, I was out of the room for a moment when I heard that they wanted to do the Paratus tape next. All I'm saying is, in light of your instruction yesterday that they edit it, I haven't seen the edit yet. I would just ask
No,
that
I indicated to you we were going to look at it one more time before it's played. I want to see the edited as well.
Right, because I may have objections about that. Thank you.
All right. All right, Deputy Magnera, the jury's upstairs still. All right, we're going to proceed with the next witness, who I take is Mr. Sims. All right, while we take the recess to bring the jury down, I had to pull a number of the Bronco exhibits for the purpose of reviewing last night. Mrs. Robertson has them available. Get your exhibits organized. Let's not lose any time fumbling with exhibits.
I need it.
All right.
Yes.
All right. We'll take 15 to bring the jury down. Get your exhibits in order. This one down for a moment, please. Since I need to see the eyeballs of the jury from time to time. As the case may be. All right, Deputy Magnera, let's have the jurors, please. and gentlemen, please be seated. All right, let the record reflect that we've now been rejoined by all 14 members of our jury panel. Good morning, ladies and gentlemen. Better. All right, Mr. Harmon, you may call next witness.
Thank you. Morning, ladies and gentlemen. Morning. People recall Gary Sims.
Please have a seat on the stand and statements for your first and last names for the record.
My name is Gary Sims, G-A-R-Y-S-I-M-S.
Thank you, Your Honor. Mr. Sims, have you conducted additional testing that you're here to provide the results on in this case?
Yes.
Okay. And just to put the additional testing in context, I'd like to put up a couple of exhibit boards, People's Exhibit 260 and People's Exhibit 172, which are the Bronco photo board, or the Bronco result board, and the Bronco photo board, respectively. And start out by just briefly discussing items 31, 303, 304, and 305 that you previously presented to the jury. Item 31, if you look at the result board, that was from the center console shown in one of the photographs, and you provided some PCR results from that. Is that correct?
Yes.
And would you just summarize what the results were and what your conclusions were without addressing any statistical aspects of those conclusions?
Yes, for item number LAPD 31, which is our item number DNA 18, the DQ alpha finding indicated a main type of 1.1, 1.2, a minor type of 1.3 and 4, and those alleles are consistent with a mixture of the defendant, Mr. Simpson's blood, and Mr. Ronald Goldman's blood. And then on the D1S80 results for that sample, the call on that was 24,25. Again, that is consistent with this same mixture.
Okay, and would you give us the same summary with respect to item 303, which was from the center console as well?
Yes, item 303 was our number DNA 52. The DQ alpha type on that was a 1.1 with a possible 1.2, 1.3, and 4. The D1S80 type was 24-25 with a weaker 18 allele. That particular mixture was consistent with a mixture of the defendant, Mr. Goldman, and also Nicole Brown.
What about 304?
304 was the same results. That was our item number 53, DNA 53.
Same as 303.
That's correct.
And what about 305?
305, in the case of 305, there was a slight difference there in that the DQ alpha type was called a 1.1, possible 1.2. The minor type in that case was a 1.3 and 4.
And what conclusion would you draw about possible sources from among the three parties whose reference samples were provided to you in this case?
Well, I would also supplement that the D1S80 results were the 24 and 25 alleles along with the weaker 18 allele. So again, that was consistent with the mixture of all three of the principles in this case.
Okay. I want to ask you a general question with regard to your PCR processing of each of these console samples that you've provided a summary of your results on. Were any of those console samples ever extracted in the presence of any of the reference samples during your handling of these samples in this case?
No.
Okay. Are you familiar with Dr. Gertie's testimony with regard to some of your results in this case?
Yes.
And what's the basis of your familiarity? Have you read excerpts of his testimony?
I listened to some of his testimony when I was monitoring it. I also have read some of the transcript.
And have you also been provided with a copy of a defense exhibit in this case, Defense Exhibit 1309?
Yes, I believe, is that the, I'm sorry, could you explain which one 1309 is?
Well, once you take a look at it, it appears to be a photo of a set of DQ alpha strips. Why don't you take a look at the photo in the left-hand corner and see if you recognize the photo of the complete set of strips reflecting work that you did in this case.
Yes, I do.
Could you briefly summarize, and I want to solely ask you to focus on LAPD item number 31, the center console item that you just provided us a summary of your results for. Could you describe, based on your reading of Dr. Gertie's testimony, the nature of his concerns about item 31, and solely with respect to the DQ alpha testing?
Objection to summarizing the testimony.
Rephrase the question.
Sure. What are the concerns that Dr. Gertie's expressed with regard to item 31?
Same objection.
What's the first concern?
What is the first concern that Dr. Gertie's expressed with regard to, specifically with regard to LAPD item 31?
The concern that I was aware of was the determination as to whether or not that 1.3 dot was in fact a real allele showing up or an artifact. That was his concern.
Okay. Do you agree with the concerns that Dr. Gertie's expressed to this jury when he testified and discussed Exhibit 1309?
Well, I disagree with him in that his conclusion was that one could not say with confidence that the 1.3 allele was there, and I disagree with that.
And solely focusing on LAPD item 31 and the testing that you actually performed, and you're the only one that performed testing on that sample, why do you disagree with him?
Well, just for the record, I should state that this analysis was performed by Renee Montgomery, and I was the second reader on this particular date.
Okay.
I disagreed with him because of the relative intensity of the 1.3 dot in this case relative to the C dot within this particular strip.
And what's the basis for your opinion that you're correct in calling that?
Well, the call that was made at the time that this strip was developed included the findings of the 1 dot, the 4 dot, the 1.1, the 1.2, etc., the 1.3, and the all but. And the finding of these two dots, the weaker dots here being the 4 and the 1.3, was that they were of similar intensity to the C dot.
In an effort to unravel or determine the potential sources for all of the blood stains that were tested on the console, on the Bronco console, did you continue to perform testing on items 303, 304, and 305? Continue beyond what you've already described to this jury?
Yes.
And what, just generally, what did you do?
What I ended up doing, may I sit in? What I ended up doing was noting that the overall quantity of DNA that was individually extracted from those three samples, 303, 304, and 305, appeared to be insufficient for an RFLP type analysis. So what I did was to individually look at the types from those samples, and then I made a determination to combine those extracts, the extracted DNA from all those three samples, to get enough DNA so that I felt I could get an RFLP result by the collective, the bringing together of those three samples from the center, all from the center console.
We're going to talk about that a little bit, but would you just describe the relative amounts of DNA that you detected in those individual samples, 303, 304, and 305?
Yes, I can do that. I need 1 second to refer to my notes. From 303, which is our item DNA 52, there was about 40 nanograms recovered in that original extract. From 304, which is our DNA 53, there was about 29 nanograms. And then in the original extract of 305, that was around 17 nanograms approximately.
Now, why did you feel it was appropriate to combine those stains in order to pursue the RFL, or strike that? Why did you feel it was necessary to combine those three stains in order to try to perform RFLP testing to produce results from those stains?
Well, it was clear to me that we had a mixture of DNA DNAs from different individuals in these samples. And individually, for a typical individual stain, we like to get about 50 nanograms to test in our laboratory for an RFLP analysis. And I knew that given these were weaker mixtures, that it would be very difficult to get that kind of DNA to show up on one of these autorads that we've seen so many of without having enough quantity. So the only way I felt that I could get enough quantity to do that was to combine them. In other words, I could individually test them for these sensitive PCR tests, but to get enough for one of these RFLP results, I felt that I had to combine them.
Okay, and why did you feel it was scientifically appropriate to combine those three stains in order to perform RFLP testing?
Well, I looked at this in a very stepwise fashion in terms of looking, first of all, at the consistency of the PCR results in the different systems that we tested, DQ alpha and D1S80, also knowing that they were all collected from the center console, the Bronco. I felt that, in my forensic opinion, that was the same general blood-stained area, so that it would be reasonable and certainly feasible to combine them.
In your opinion, do your RFLP results, which we will show to the jury in a few minutes, on the mixtures that you've just described for us, do they corroborate your interpretation of item 31, the center console, where you concluded that the possible sources would be Mr. Simpson and Mr. Goldman?
Yes.
In what sense do they corroborate them?
Well, the finding of those, of the RFLP patterns that are consistent with those two individuals, Mr. Simpson and Mr. Goldman, tends to corroborate the results in item number 31, which is also a center console blood stain.
Strike with respect to item 31, talking about 303, 304, and 305.
Had you finished your answer?
Yes.
Okay. And in your opinion, do your RFLP results, which we'll show to the jury in a couple of minutes, do they tend to undermine the reservation or criticism expressed by Dr. Gerdes that you've described to the jury just a few moments ago?
Objection, move to strike. It's not Dr. Gerdes' testimony about 303, 304, and 305.
Leading to phrase the question.
Mr. Sims, in your opinion, do your RFLP results from the mixtures that you've performed or that you've just briefly described to this jury, do they tend to undermine Dr. Gerdes' opinion and
What's the impact?
Mr. Sims, what's the impact of your RFLP results on the combination of 303, 304, and 305 on Dr. Gerdes' criticism about the 1.3 allele in item number 31 from the center console?
Objection, move to strike with respect to item 31.
Overrule.
Well, I think the RFLP results do tend to undermine that because they do show consistency with what I originally called on item number 31, which Renee Montgomery also called on item number 31, namely that those DQ alpha results were consistent with a mixture of Mr. Simpson and Mr. Goldman.
Okay. In addition, Mr. Sims, do your RFLP results from the combined stains on the center console also corroborate the PCR results that you've briefly summarized from those same stains on the center console?
Yes.
In what way?
Well, again, the finding on the RFLP results is that it is consistent with a mixture of Mr. Goldman and Mr. Simpson. You'll recall that on the PCR results we saw a little bit of this 18 allele. This was the weak allele on the D1S80 results on those gels. I believe what we're seeing is that weak type that is detectable by the very sensitive PCR methodology is not detected by the less sensitive RFLP approach.
And what do you say about the remaining types that are consistent with Mr. Simpson and Mr. Goldman from the PCR? Is that what you see in the RFLP results?
Yes.
Mr. Sims, do the combined stains from 303, 304, and 305, the RFLP results, tend to address any concerns about PCR's exquisite sensitivity?
Yes, I believe they do, because you've heard extensive testimony about the sensitivity issues with PCR. The RFLP is not as vulnerable to those concerns as the PCR is.
Mr. Sims, do the mixture results from stains 303, 304, and 305, the RFLP results, tend to address concerns about potential cross-contamination among samples?
Objection. Right.
Oral.
Yes, I believe they do, because to get an RFLP result, you need a substantial amount of DNA from a blood sample, particularly when you're comparing that to how sensitive the PCR test is.
Okay. Your Honor, at this time, I'd like to have marked as people's next in order a set of 4 autorads in a plastic cover. What would that number be?
Mrs. Robertson, people's next in order. 616.
616.
Six-
I'm sorry.
Did you want to mark them 616 A, B, C, and D?
Yes, and I'll describe, so we can correlate them later without actually marking. I'll describe the order that we'll be showing them. As 616A, the autorad is labeled D10S28. As 616B, it's autorad D4. As 616C, it's D5. As 616D, it's D2, Your Honor. Mr. Sims, I'd like to show you a set of 4 autorads, 616A through D, and would you tell us if those represent the 4 autorads that were produced as a result of your combination of those 3 stains, 303, 304, and 305?
Yes, they do.
And we've actually put labels on them that you didn't put on there to show the names and identify the stains. Is that true?
That's correct.
Okay, Your Honor, I'd like to show them to the jury and have Mr. Sims use the telestrator. I'd like to show 616A. Yeah, here.
Can we clear these artifacts? Mr. Harmon, we appear to have artifacts on the telestrator. There we go. Thank you, Ms. Martinez.
Mr. Sims, can you help get the jury reoriented on the autorad reading 1 here and describe what they're seeing so they can understand the results?
Yes, this is now an autorad from a gel which contains the combined 303, 304, and 305 from the console, and that's labeled console in that particular lane. And you recall these samples run downwards from the top to the bottom in the vertical lanes. Then we have a reference sample from Mr. Goldman, we have a reference sample from Mr. Simpson, and then a reference sample from Nicole Brown to the right side there.
Okay, and so the lane that's labeled console, that represents the combination of 303, 304, and 305?
Yes.
Is that right? And then, and the reference samples is Mr. Goldman, Mr. Simpson, Ms. Brown?
That's correct.
Could you describe your results and what your conclusions are without addressing any statistics?
Yes, the finding of that pattern in the console lane is consistent with a mixture of the banding pattern of the defendant, Mr. Simpson, and also the contribution from Mr. Goldman.
Could you, is there any way that you can show which bands match which by using different colors for the different reference samples?
Yes.
Why don't you do that?
I'll mark the lanes in the console in, I guess that's a sort of a lavender or pink color, that are consistent with the defendant's bands. And I'll also mark those lanes, I'll mark those bands in the defendant's, Mr. Simpson's lane.
And then what about there seems to be, on the reference sample of Mr. Goldman for this probe, it looks like he's just got one band. Is that true?
Yes, this was scored as what we call a single band pattern down in this area. It's possible that he has two very close bands in this area, but they tend to run together in all the samples that we saw in this case every time we ran his sample. It's a single band pattern. So instead of having two bands, he just has one that's scored. And I'll mark in green his position in his reference lane, and now I'll mark that band also in the console lane. The other thing that's significant to me in this particular mix is that,
Excuse me, counsel, not responsive to a question.
Is there anything else that's significant to you in this particular mix?
the other thing I wanted to mention, and we'll see this as we go through the total picture of these different autorads, is that the bands that are consistent with Mr. Simpson's sample are consistent with the stronger bands in the console lane, whereas the bands that are consistent with Mr. Goldman's sample, his reference sample, are consistent with the weaker bands in the console lane.
And is that true with each of the four autorads that will be shown to the jury?
Yes.
And does that somehow relate to the amounts of DNA in those, in your opinion?
It relates to the relative contributions from each individual.
All right, Mr. Harmon, you want to print this out?
Yes, Your Honor. May that 616A1? And can we, as soon as we're ready, put up B? Okay, Mr. Sims, we're looking at 616B now. You've already given the jury the orientation on that. What do these results reflect, in your opinion?
This is an autorad developed from the locus D4S139. Perhaps we can brighten that up a little. That's pretty good.
Is this the best way to look at autorads, projecting them up on the screen?
That's not how we do it in the laboratory.
You look at it on a light box?
Yes, we study them under a light box,
Okay.
or over a light box.
Sure. Why don't you describe what you observed and what conclusions you drew from 616B?
Yes, from 616B, again, this is the locus D4S139. Again, the console lane has, in this case now, 4 bands. This is consistent with a mixture of the defendant's sample and Mr. Goldman's sample. And I will mark the bands again, as I did previously in the console console lane, I'm marking in the pink or lavender the bands that are consistent with Mr. Simpson's bands. And now I'll mark them in his reference lane. And now I'll mark in green the bands that are in the console lane that are consistent with Mr. Goldman's bands.
Now, in this instance, Mr. Goldman's reference type and the corresponding evidence stain have two bands, is that correct?
That's correct. He has a two-banded pattern, which is the typical pattern in an RFLP, is a two-banded, but sometimes you'll see one, for example. And now I'll mark in green the bands of Mr. Goldman in his reference lane.
And I neglected to ask you this with regard to 616A, but Ms. Brown is excluded as the source of any of the typing results on the console combination. Is that true?
I didn't detect her band pattern in these auto-rads.
And the pattern you detected was inconsistent with her?
Yes.
Okay. May that be marked as 616B1, Your Honor? Can we put up 616C? Why don't you describe what's of significance in 616C, Mr. Sims?
Again, this is the same gel, but now this is the locus D5S110. Again, we see a pattern in the console lane that is consistent with the mixture of Mr. Goldman and Mr. Simpson. Again, the bands that are the strongest in that console lane correspond to Mr. Simpson's bands. The two weaker bands correspond to Mr. Goldman's bands.
Could you mark them with the corresponding arrows and colors that correspond to 616A1 and B1?
Yes, I'll use the lavender arrow to indicate the bands in the console lane that are in agreement with the bands seen in the defendant Mr. Simpson's reference lane. And now I'll mark those corresponding bands in Mr. Simpson's reference lane. And now, switching to the green arrows, I'll mark the bands in the console lane that are in agreement with the bands in Mr. Goldman's reference sample. And now I'll mark in green the corresponding bands in Mr. Goldman's reference lane.
And may we capture that as 616C1, Your Honor?
Yes.
Okay, we're looking at 616D now, Mr. Sims.
Yes.
Why don't you describe to the jury what you see on there and what conclusions you drew from the results?
Yes, this is now the locus D2S44. This is the final autorad I'll show you today. This is a more difficult call on this particular lane with regards to the console, because you can see that Mr. Goldman and Mr. Simpson have fairly close bands as far as their upper bands are concerned, and I'll talk about that as I look at as I explain to you the console pattern. But I think you can see. I'll point with the lavender arrow at the bands in the console lane that are in agreement with Mr. Simpson's bands. And now I'll mark those corresponding bands in the lavender color in his reference lane. And now with the green arrow, I'll first mark, I'll go backwards a little bit here. I'll first mark the bands in Mr. Goldman's reference lane, here and here. And now we'll talk about the console lane, because this is a little more difficult to see. There's a band in this position, this lowest position in the console lane where I'm pointing now with the green arrow, that is in agreement with Mr. Goldman's lowest band. Now the difficulty arises when looking at this particular area right above the band that corresponds with Mr. Simpson's band.
The upper band.
The upper band. This autorad was reviewed by myself and then independently by a second reader. We felt that there was an indication of a band here, but we could not score that as a clear band. In other words, it's not clear and distinguished enough that we could make a determination that that is a band that's sitting on top of that one band. They're just too close to call, and it's just not clear enough. And so we did not score that as a band.
It's too close to what?
It's too close to the band that corresponds to Mr. Simpson's band in his reference sample.
Okay. And if what you see there really is a band, does that correspond to Mr. Goldman's other upper band?
Yes, it would.
Could you point to the area that you believe you saw some activity?
Yes, I'll point to it with the, perhaps I should use another color.
That's okay. We've described it as upper, so.
Okay, I'll point to it and mark it with the green arrow.
Okay. Can we capture that as 616D1, Your Honor?
Yes.
And actually, is there a fifth probing going on as we speak?
Yes, there's another film that if I get back today, I'll look at this afternoon.
Okay. Mr. Sims, why don't you go up and have a seat? I just have a couple more questions here. Mr. Sims, is there any question in your mind that the RFLP results that you've described to this jury represent a mixture more than one source?
No, there's clearly a mixture of DNAs in those samples.
And you've already described to the jury the significance of the relative intensity differences in the bands, and you can see what they are, especially on 616D. Is that true?
Yes.
What significance is there to the fact that you never observed more than 4 bands in the combined stamps on the console?
That would indicate that we are seeing most likely DNA from just 2 individuals, not more than 2 individuals.
And just to make sure there's no confusion, because of the relative sensitivity of PCR with respect to RFLP, these RFLP results in no way undermine or contradict the PCR mixture results you previously provided to the jury. Is that correct?
That's correct.
Okay. Thanks, Mr. Simpson.
Check. 5 minutes, or you want to take a break?
Let's take a break.
Your Honor, I neglected. We have a patch. I just wanted to complete his testimony by placing this patch
Well,
on.
why don't you ask,
Can we do that on
Go
the
ahead.
record?
no, why don't you do it on the record? Go ahead. No, let's let Mr. Harmon, let's say, right.
Okay, may the record reflect on the Bronco result board. I'm placing vertically to overlap the RFLP column on 303, 304, and 305, a label that says console mix 4 probes.
Okay. So noted. All right, ladies and gentlemen, we're going to take our mid-morning recess at this time. Remember all my admonitions to you, and we'll see you back here in about 15 minutes. All right, Mr. Sims. All right, back on the record in the Simpson matter. All parties are again present. All right, Deputy McNair, let's have the jurors, please. Be joined by all the members of our jury panel. Mr. Sims, would you resume the witness stand, please? All right, Mr. Harmon has completed his direct examination, and Mr. Scheck, you may commence your cross-examination.
Thank you, Your Honor. Good morning, ladies and gentlemen of the jury. Mr. Sims, good to see you.
Good to see you.
Let's see if we can...
All right, you're going to put up again Peoples 172.
Yes.
All right. Got it?
And if we could look, just to clarify some of the facts here, at Peoples 172 and also the results board, Peoples 260, to understand precisely what you have done here. Now, first of all, items 30 and 31 are depicted in the upper right-hand corner, is that correct?
Yes.
Of the of Peoples 172. And those represent swatches that were made on June 14th.
Yes, that's my understanding, that those two stains were collected about June 14th.
On June 14th by Dennis Fung and Andrea Mazzola.
I'm not sure who collected them, but the date sounds right to me.
And each picture on this board, 29, that's the steering wheel you told us about, right?
Yes.
All right, that's the one with the 1.1, 1.2, and 4, correct?
Yes.
And the next picture over 33, another picture of the steering wheel, 29, 33 again, 22, 23, 34, the picture just showing 25, 26, 27. All those pictures were of collections made on June 14th, 1994. That's your understanding, correct?
That's my understanding.
And 293 is a carpet that was pulled out of the Bronco on June 14th, correct?
That's my understanding. The carpet was pulled out on that day.
All right. Now, samples 303, 304, and 305, those are the samples that you combined to do your new RFLP test, right?
Yes, 303, 304, and 305.
And they are depicted at the bottom right-hand corner here from the console.
Yes.
And those stains were collected on August 26th, correct?
Yes, my understanding is it's about that date.
Okay. Now, the results you got on the Bronco samples that were collected on June 14th are shown in the result board here. That's 30 and 31, correct?
Yes, I believe those are the ones, although 34, I think, and 29 were also,
I'm talking about the console.
console, I'm sorry, 30 and
That's
31.
my question,
Yes.
right? The console.
Yes.
Now, 30, as depicted in the upper right-hand corner, from that swatch collected on June 14th, you got a 1.1, 1.2, 24, 25, correct?
Yes.
And that is a DNA typing that is consistent just with Mr. Simpson.
Yes.
And from that typing, there is, you can exclude Ronald Goldman and Nicole Brown Simpson.
Yes. None of their DNA shows up in that sample.
Okay. Now, the result from 303, the sample taken on August 26th, right?
Yes.
All right. Which is that one on the DQ alpha and D1S80, you got results that were consistent with Mr. Simpson, Mr. Goldman, and Nicole Brown.
That's correct.
And in theory, it's your understanding that 30 and 303 were taken from the same area.
Objection calls for speculation. This states the testimony.
Sustain.
Is it your understanding that 303 and 30 were supposed to be bloodstains in the same area?
Objection, that's vague, calls for speculation.
Overruled.
I remember we went through all this in May, and I think we got down to the issue of what are we talking about when we're saying it's exactly the same area?
I didn't say exactly the same. Same general area?
Same general area, yes.
Right?
I would agree
That's
with
what the reports you got indicated.
that. Same general area.
Thank you. Now, 31, okay, that's the second stain from the console from June 14th, right?
Yes.
And that's the one that you say has a DNA, a DQ alpha profile that is consistent with Mr. Goldman.
Yes.
All right, now. Your Honor, I'm, for the sake of, I don't know if it can be seen at the end, so I'll just try to put it on the middle. Now, Mr. Sims, 31,
All right, I'm sorry, Mr. Sheck, you just put up defense exhibit.
1309.
Thank you.
31 is the item, 30 and 31 are depicted here in defense 1309. Is that right?
Yes, the DQ alpha strip.
And in the upper left-hand corner, we see all the strips that were run that day.
Yes.
Now, you recall we discussed this, you and I, on cross-examination.
Yes.
And you would agree when I asked you those questions on cross-examination, the issues probably weren't so clear the way I did it that day with dots.
I thought it was clear.
Well, you thought it was clear. I apologize. But when Dr. Gerdes testified, he made points that were similar to precisely the points I was making with you when we visited this issue on cross-examination.
Objection, that's vague, no foundation.
It's argumentative. Sustained.
Argument.
All right. Now, you stated on direct examination one of the concerns that Dr. Gerdes expressed with respect to this 1.3 dot, correct?
Yes.
Now, wasn't one of the points that Dr. Gerdes made is that there was also evidence of the 1.3 dot appearing on the quality control sample 816 and the positive control in the same run.
Objection, that's beyond the scope.
Overruled.
Yes, he mentioned that in his testimony.
Right? And he took the position that scientifically, when your controls are showing 1.3s that shouldn't be there, it is improper to call a 1.3 that is also faint within a mixture. You remember he made that point.
Yes.
And your protocol, as we discussed when I cross-examined you, does say that if the quality control and the positive control fail or show unexpected results, that the procedure is to do it again.
That's what we would say, yes. In other words, if they show, I think the key word is whether or not they fail. In my opinion, they didn't fail.
I understand that, but you did not do this again.
That's correct.
However, and this is,
All right, Mr. Chairman, just be careful, because that easel
I
has
understand, I
a...
think I've got it.
Okay, it's got a limited capacity. All right,
1310.
1310, thank you.
However, on item 52 on board 1310, there was what you in your terminology call this 1.3 trace,
Objection.
correct?
It's beyond the scope, Your Honor. This is different samples.
Overruled.
Yes, it was called a C-/trace.
Right. And you also saw on one of the quality assurance sample in this run, what you called a trace of a 1.3?
Yes, I believe that's right, but I'd like to quickly check the note sheet for that day.
Would you accept my representation that this came from your note sheet? That's your
And that is my recollection.
And that on the positive control, it was a hint/trace?
Yes, in other words, there was more of a dot showing on this particular positive control than the previous one you showed me.
And that you decided, based on this data, to do it again.
That's correct.
And the 1.3 here, item 52 is a Bundy blood drop.
Yes, it is.
And if that 1.3 were a real allele, then that would indicate that there was perhaps more than one contributor to the stain you had there.
Objection. 52 is beyond the scope of the record.
Overruled. But let's,
Yes, we're moving through it.
yes.
Yes, you recall that?
Yes.
Okay. And you did it again,
Yes.
and in your notes, even though it's not really visible on this strip, it was recorded very faint trace,
Yes, I believe that's correct, but I rehided it.
and the rehive indicates that the film was developed for 22 minutes,
I believe that's correct, yes.
and your protocol is to develop them between 20 and 30 minutes.
Yes.
And would you agree that the amount of time that you develop them may relate to the intensity of the 1.3 dot?
Well, beyond about 20 minutes, there's really very little difference in those. It's mainly what happens in the first 20 minutes that's the issue.
Well, you didn't indicate on the sheets how long the original run of item 52 was developed.
That's correct. I consulted with Renee Montgomery later on.
All right. Now, to finish this up, you recall that Dr. Gerdes criticized your results by saying that it was inconsistent to call this 1.3 not real and without further testing to call the 1.3 on sample 31 real.
I believe that was his testimony, yes.
Okay. So those are some of the concerns that Dr. Gerdes expressed with respect to full rendition of his concerns with respect to sample 31. Fair statement?
I think that covers about everything.
Okay. And just so we're all clear, with respect to the console of the Bronco and the samples that were collected on June 14th, the only evidence from DNA testing that you have with respect to the console is that 1.34 finding that you and Dr. Gerdes disagree about on item 31.
Yes.
Okay. Now, with respect to the results on 303, 304, and 305, You recall that Dr. Gerdes expressed the view that the integrity of the evidence had been compromised by the way in which the Bronco was handled between June 14th and August 26th. Do you recall that?
That misstates the testimony. That's argumentative. That's not what he said. It's beyond the scope of the direct examination.
Overruled.
I believe I saw that in his testimony, yes.
So you recall that with respect to his opinions about 303, 304, and 305, that was a concern of his.
I believe that was a concern, yes.
And do you have some familiarity with the way the Bronco was handled between June 14th and August 26th?
Objection, no foundation.
Sustained.
Offer speculation.
You can ask him if he took that into consideration.
Mr. Sims, from what you know about the way the chain of custody for the Bronco was handled between June 14th and August 26th, do you think it was handled appropriately in your forensic opinion?
Well, I don't know the whole history of how that Bronco was maintained. I don't know the whole history of that. I've heard that there were some
Objection, that calls for hearsay.
Overruled.
Calls for speculation. No
Overruled.
foundation.
It's an expert opinion, counsel.
I,
Please continue.
Overruled.
I've heard that the defense has raised some issues with regard to that. I don't know the truth of the matter on all these issues, no.
Object, that's not responsive. Move to strike. There's no foundation.
Overruled.
Mr. Sims, you heard Dr. Gerdes testify about it.
I heard him express concerns. I don't know what his basis for those concerns were, other than the general term chain of evidence.
You have no knowledge with respect to whether or not this Bronco was secured for further biological analysis between August 26th and June 14th in a way that would preserve the integrity of the evidence. You have no knowledge of that?
Well, I know what I see in the newspaper, and I know, for example, that I think 2 weeks ago you called a witness that addressed some of those issues, but that's what my knowledge is.
And you have not familiarized yourself then at all with what the history was of how the Bronco was kept? Is that what you're telling us?
Sustained. Rephrase the question.
All right. Have you, let me try it this way. Mr. Sims, in your forensic opinion, based on your experience,
Is it necessary for him to be down there at this point? Simply because we ought to use the microphones when we have them available.
okay, if you could resume. I think it would save time if I keep the boards up to start using them.
All right, go ahead.
Mr. Sims, to try to cut to the heart of it quickly, let me ask you to assume that between June 14th and August 26th, the Bronco automobile was put into a tow yard, that no records were kept as to who entered or left it between June 14th and August 26th, that unauthorized personnel were in and out of that Bronco automobile, that is, non-police personnel. They were in the seats, they were looking around the car. Would you consider that an appropriate way to preserve the integrity of biological evidence?
Well, I don't think that should be allowed. I don't think one should be allowed to come in and out of a car. I think that should be done by authorized people.
And that record should be kept as to who has access and doesn't have access to the vehicle if you're going to preserve blood evidence for future biological testing.
Well, when you put it in the context of records should be kept, I don't know. I mean, for example, there may be other tow yards that I've been involved with in forensic cases where perhaps just one person has the keys, so there's no record kept of all those things, but that should be controlled. Access should be controlled.
So your answer is yes.
Well, with what I added to that, yes.
Now, so basically, you have no basis for disagreeing with Dr. Gertie's judgment that the integrity of those samples, 303, 304, and 305, was compromised by the chain of custody procedures used in this case?
Sustain.
All right. You heard his testimony that he believed as a scientist that the chain of custody for these samples compromised the integrity of future analysis. You recall that?
Yes, I heard some of that.
And you're saying to us that you are really not familiar with the details of the chain of custody of the Bronco.
That's correct. I'm not familiar with those details.
And you have not endeavored to become more familiar with the exact details of how it was kept and who was in and out of the car.
That's correct.
And therefore, you wouldn't want to render an opinion on it because you don't have enough information.
Opinion about what?
Well,
I think I did offer the opinion of what should be done with that kind of evidence as far as securing it, yes.
All right. So your general opinion that it wasn't handled properly, but you don't know the specific details of how bad it was.
Well,
it is.
I'll move on. Now, just so we're clear, what you have done since we last visited is that you combined the samples that were found on August 26th, 303, 304, and 305, and you put them together. Is that correct?
yes, I've put them together.
Now, altogether, when you did the quantitations on all these stains combined, you came up with 72 nanograms of high molecular weight DNA.
Well, there was actually more than that, I believe, after, but some other tests were run in between. But it's about 72 nanograms.
About 72 nanograms.
Yes.
And looking at the results, you believe this to be a mixture.
Yes.
And the predominant contribution in the mixture is DNA that you say is consistent with Mr. Simpson.
Yes.
And that's something on the order of 3 to 1.
Yes, I would say it's somewhere in 3 to 1, maybe 2 to 1, but that's the right ballpark.
And therefore, the amount of DNA on the RFLP tests that is consistent with the profile of Mr. Goldman would be something on the order of 20 nanograms of DNA.
So, somewhere in that area, yes, that's a reasonable approximation.
And that's why you had to put these probes, keep these probes cooking, so to speak, for 15 or 16 days to try to draw up the amount of DNA because there was comparatively a small amount there.
Yes, technically what's going on is that there's a low amount of DNA on that membrane, that southern blot that we made, which means that there's a low amount of radioactive probe that's binding, and so you have to let the film that's developing, you have to let that film go for a longer period of time. Usually we do these in a couple days, but for this type of sample, you have to let it go a week or longer to get those weak bands to show up.
And this is really at the, so 20 nanograms of DNA, that's really at the low end of your ability to detect, isn't it?
Yes, this is getting to the low end of the ability to detect.
Small amount.
Small amount.
Now, if we were to look at, give us some perspective. 1 drop of blood contains about 1,000 nanograms of high molecular weight DNA.
Yes, about 1,000 nanograms or 1 microgram, yes.
And in fact, you've seen estimates in the NRC reports and other places that some people put it at between 1 and 2,000.
Yes, it's in that area.
Now, if you, based on your quantitations, were to combine the amount of DNA that you got as a whole in 305, 304, 303, the August 26 collections, and for just the purpose of this hypothetical, let's also include the amount of DNA that came out of the swatches from 30 and 31. Are you with me?
Yes.
would you not agree that combining all of those together, all that from the console together, the amount of DNA would not exceed 100 nanograms?
Well, it might slightly exceed that, but it's around that ballpark.
Around 100 nanograms.
Around 100 nanograms, yes.
So that's 1/10 of one drop of blood.
Well, you have to remember that with a drop of blood, for example, if you're testing liquid blood, that's not the same as extracting DNA out of a stain's worth of one drop of blood. So you're not quite talking apples. You're somewhat talking apples and oranges there, but in terms of the ballpark, you're talking about, maybe getting 3/4 of that DNA out. So, you can figure it from that.
So, what you're basically saying, Tess, is that maybe if you're just dealing with a pristine drop of blood, you won't get 1,000 nanograms, you'll get 750. Is that what you
Something
just said in English?
Yes, that's what I just said.
Okay. And if we were to, and I mean no disrespect for that, just summarizing it. And so if you've got about 100 nanograms of DNA and there's 750 nanograms in a drop of blood, can you give me that fraction quickly? That would be, what, about a seventh?
Something like that.
Okay.
Something like that, yes.
So certainly just reasoning from the DNA alone, the amount of blood, just looking at the DNA in the console, as you've said, is in the area of 100 nanograms of DNA.
Yes.
Objection, that assumes that it was all collected.
Overruled.
Well,
Overruled.
That's object to
Overruled.
the...
Overruled.
Oh, okay.
may I answer?
Oh, you actually overruled that speaking
Calls for
objection?
speculation. It calls for speculation.
I overruled the objection.
It's a different one, right?
Ask your question.
Oh.
Next question.
Overruled the objection.
Can I finish my answer to that?
Oh, I'm
Your
sorry.
I
Never mind.
thought you did.
I meant sustained, is what I meant.
That's what I thought you meant.
That's what I meant.
Okay. It's,
Here's the problem. The moment I start to think about something else, never mind.
I,
Proceed.
thank you, Your Honor. Okay, now, you also were asked some questions on, withdrawn, I'll start this way. Now, you don't know anything about the order in which blood was deposited on that console.
No, I don't know the order in which the blood was deposited.
Are you familiar with the testimony of Dr. Baden in this case, that Mr. Simpson told him that he had cut himself on the evening of June 12th, I believe, and that he had gone into the Bronco searching for his cellular phone?
That calls for hearsay, there's no foundation.
This was his testimony. And
Overruled.
with a small cut on the side of his finger, and had bled within the Bronco. Are you familiar with that testimony?
Same objection. It calls for hearsay, there's no foundation.
Overruled.
Misstates the testimony.
Overruled.
No, I really wasn't interested in the doctor, is it Baden, how you say it, isn't it? In his testimony. I don't recall his testimony on that issue.
But, all right, just looking at it then from the point of view of forensic DNA expertise that you have, ask you to assume that there was an initial deposit of Mr. Simpson's blood on the Bronco from a small cut. And I ask you further to assume that at a later point in time, there was a second deposit. All right? Have that hypothetical?
Okay.
And if one assumes, for the sake of argument and for the sake of this hypothetical, that the blood stains of 303, 304, 305, all right, were all present also on June 14th, all right? Just asking you to assume both of these there's no question, just for the purpose of this hypothetical, that everything that was in August 26th, right, that was found there, was also present on June 14th. Just for the purpose of this hypothetical. Are you with me?
Okay, on June 14th versus
Right.
August 26th. Okay, those are the two collection times.
Right?
Okay.
But if we assume that on August 26th, the finding, the stains there, 303, 304, 305, were also present on June 14th, but somehow they were missed, okay?
Okay.
Your conclusions with respect to mixtures are not inconsistent with two deposits at two separate times.
Objection. I see a proper hypothetical. This statement of testimony, there's no foundation for that.
Overruled.
Okay, I understand the hypothetical, but now give me the last phrase, please. The question.
In other words, your findings here of mixtures are not inconsistent with a contribution of Mr. Simpson's blood at one point in time, and then a subsequent contribution of blood from Mr. Goldman at a subsequent point in time.
That's correct.
And in fact, based on all the testing that you did, most of the blood, if we withdraw, most of the DNA that you extracted from that console is consistent with Mr. Simpson.
He is, in the samples that we looked at, he would be consistent with the main contributor of that DNA mix.
Something, when you combine 303, 304, and 305, something on the order of 3 to 1.
Yes, that's a reasonable figure, something like 3 to 1, maybe 2 to 1.
Now, finally, you have continued testing. Are you still continuing testing in this case?
Well, as I mentioned, there is another autorad that I'd like to look at this afternoon, another probe, another one of these autorads that we're developing.
Have you tested item 1, the speck on the door that was first observed by Detective Furman?
Sustained.
Do you have DNA samples from the handrail? Have you tested that?
Objection is beyond the scope.
Sustained.
Excuse me for 1 second. Approach the bench for just 1 minute. Scope.
Proceed.
On a scope file, I don't want to ask a question.
All right, with the court reporter, please.
Take just a second.
All right, thank you, counsel. Proceed.
Now, Mr. Harmon asked you some questions on direct examination about these RFLP results allaying concerns that Dr. Gerdes expressed with respect to cross-contamination. You recall that?
Yes,
He asked you that question very generally, didn't he?
yes.
Now, these RFLP results only deal with samples 303, 304, and 305.
That's correct.
These RFLP results do not address any issues of cross-contamination with respect to the Blundy blood drops 47, 48, 49, 50, and 52.
Objection, that's vague, Your Honor.
Overruled.
No, these results relate to these samples.
All right? They don't relate to any problems of cross-contamination that occurred in the evidence processing room on June 14th when Colin Yamauchi examined the Rockingham glove.
Objection, it's beyond the scope.
Overruled. But you can generalize this.
I'll just only have 2 or 3 more questions just to show what it doesn't concern.
It also misstates the testimony.
Overruled.
The question again,
The
please.
question is, these RFLP results don't address the issues of cross-contamination that have been raised by Dr. Gerdes concerning Colin Yamauchi's handling of the Rockingham glove in the evidence processing room on the morning of June 14th, right?
I'm trying to recall what issues Dr. Gerdes specifically raised about those, because I don't recall seeing any issue with those particular samples.
Well, you don't recall his testimony about that? Is that what you're telling us?
I don't recall the details of his testimony about those particular samples.
You don't recall his testimony about Mr. Yamauchi? All right. You don't recall it? Is that your
Well, I
testimony?
said I don't recall all the details. When you start talking about issues, you're putting a plural on it, and you're
Mr. Sims,
implying there's some.
Mr. Sims, even if you can't recall all the details of what Dr. Gerdes said, you don't believe that these RFLP results on 303, 304, and 305 had anything to do with it?
Objection, it's argumentative.
It is.
Do you believe they have anything to do with it? Do
Well-
they address those concerns about cross-contamination?
I think in the narrow sense of your question, no. The answer is no, they don't address that.
Thank you. Now, Dr. Gerdes gave extensive testimony concerning a study he performed of contamination at the LAPD laboratory and the efficacy of controls and sample handling procedures used at the LAPD laboratory. You're familiar with the fact that he testified about such a study?
Objections beyond the scope of direct
It's
examination.
my last question in this
Overruled.
line.
Yes, I'm aware that he presented that.
You didn't read that study or review his data, did you?
No, I did not.
Now, Your Honor, and we just think about it, but I actually think I'm finished. Your Honor, I have no further questions, but I would request, based on what we've discussed, that this witness be subject to recall on another matter.
All right, no, Mr. Sims, we know where Mr. Sims is, and he knows how to get to L.A. All right. Mr. Harmon, do you have any redirect examination for Mr. Sims?
Just taking up with that last point, Dr. Gerdes' study about LAPD, do you recall that Dr. Gerdes was unable to recount the history of from the sample collection of 303, 304, and 305 when Mr. Clark asked him to recite that to the jury?
So far as he said, he doesn't remember his testimony completely.
No, I did read that part of the testimony. I did review that particular part of the testimony regarding who collected the samples with regards to 303, 304, and 305.
And based on reviewing his testimony, do you recall that Dr. Gerdes made no specific technical criticisms of your PCR results from 303, 304, and 305?
Yes, my recollection in his transcript was that there was no specific criticism of those PCR results.
Now, Mr. Sims, your crime scene collection days have long passed, is that right?
I haven't been to a crime scene or a vehicle, that sort of thing, in about 5 years now, over
And-
5 years.
Mr. Scheck asked you about the appropriate way to preserve evidence and keep logs of who has access to evidence. Do you recall that?
Yes.
Now, and you said that's not the appropriate way to do it.
Well, I just said that access should be controlled. I think that was the gist of my response.
The failure to keep a log of who went in and out of a car, if anyone went in and out of the car, that's not going to change the types of the RFLP results that you presented to this jury that are consistent with Mr. Simpson and Mr. Goldman, are they? Is it?
Beyond scope calls for speculation.
Oh, well.
No.
And allowing people to go into the car to look around, unauthorized people, if that actually happened, that alone is not going to necessarily change the PCR or RFLP results from 303, 304, and 305, is it?
That's correct.
What you have presented to this jury is the results of your testing, DNA testing from various samples that are provided to you. Is that true?
Yes.
Is it unusual for you not to know the history of a sample in a case?
No, it's not unusual to not know the complete history of a sample in a case.
In fact, given the way these violent crimes often occur, some history of the sample is frequently lacking when you do your testing. Isn't that correct?
Well, yes, that's true.
Let's just I'll give you a hypothetical and just so we can illustrate this. Let's assume we have a female brutally murdered, signs of sexual assault.
Objection. Calls for speculation irrelevant beyond the scope.
Oh, well.
Signs of sexual assault, evidences of vaginal swabs, parents' seminal stains on clothing are all collected and sent to you with reference samples. Are
Renew
you
the
with me so
objection on
far?
relevancy grounds.
Oh, well. Haven't
Yes.
heard the question yet.
Now, that's not an unusual case to be presented to you in the DOJ lab, is it? Evidence like that.
No, that would be a typical or not unusual.
And it's not unusual for you to perform tests on those samples, isn't that true?
Yes.
And in cases like that, you have frequently identified people as the source of sperm in apparent sexual assault murder cases, isn't that true?
Yes, for example, we've used the DNA to say who could be a potential source of that particular semen sample.
Now, when you do those testing, or that testing, based on the test results alone, you can't necessarily tell whether the sex act that produced the sperm occurred before the homicide, can you?
That's correct.
You can't necessarily tell that the sex act that produced the sperm occurred during the homicide.
All right. This is irrelevant.
We're about to become irrelevant.
About two more questions, they'll be totally irrelevant, Your Honor. You can't tell that the sex act that produced the sperm occurred in any relationship to the violence that caused the homicide, can you?
That's correct.
And last question on this point, you can, for example, you might be identified, or the sperm that you produce might be someone who had sex with a person who's been murdered where the sex act occurred after the homicide.
Possible.
It's another effortless last
All right, let's move on.
Now, Mr. Schecht asked you a series of questions about people having access to the car and coming into the car, and I just asked you some questions about those things wouldn't necessarily change the type of the result of the DNA that was there. Do you recall that?
Yes.
Now, in order for one person to have produced the RFLP results or the PCR results that you detected on that console, there'd have to be something terribly wrong with that person, wouldn't there?
Objection. Vague.
Sustain. Vague.
Based on your DNA results, in order for one person to account for the DNA results from 303, 304, 305, both individually and in combination, there'd have to be something terribly wrong with that person, wouldn't there?
Sustain.
Would there have to be something terribly wrong from one person if one person were to try to account for all of the results from 303, 304, and 305?
Oral.
Yes, it would be some sort of genetic anomaly.
In what sense?
Well, because you see more what we call alleles or types than you would from a single individual.
Okay. For example, you've already described the significance of seeing 4 bands, 2 of higher intensity and 2 of lower intensity.
Yes.
Are you aware of anything in the literature where one person could have 4 bands where they're of different intensities
Well,
from these probes?
the sort of thing where we might see that would be on, for example, somebody who is transfused or something unusual like that.
Well, to just add to the mystery a little bit, if in order for you've paired those results. You've paired some of them that are consistent with Mr. Simpson by relative intensity and some that are weaker than Mr. Simpson, and they're consistent with Mr. Goldman. Is that correct?
Yes, the intensity patterns, the band intensity patterns pair up between those 2 individuals.
In order for another person to account for depositing, let's say, the weaker set of bands, they'd have to match Mr. Goldman's type, wouldn't they?
Yes.
Now, the last point, or I think it's the last point at least, Mr. Scheck asked you about the console mixture results that you've described to this jury, 303, 304, and 305, both PCR and RFLP. And you said they're not inconsistent with 2 deposits, the results alone. You recall that?
The RFLP results are consistent with 2 depositors.
I didn't speak clearly enough. Are they, I think you told him they're consistent with 2 separate deposits, having come at 2 different times.
Oh, as far as the order of deposition?
Yeah, or whether they were simultaneous or at different times.
Well, I said I could not rule out that possibility, yes.
Now, is there something about the amounts of DNA in those samples that tells you that it's highly improbable that that occurred?
Well, it's hard to say too much just based on these amounts of DNA in those particular samples. I have no reason to suspect that they are from different times, but there's nothing clear to me one way or the other.
Would you say that the amounts that would be represented from, say, Nicole Brown, who is not detected in the RFLP testing, what can you tell us about that?
Well, when you enter the point now where you're talking about 3 different people's blood on a console in a vehicle, I mean, forensically, that seems very significant to me. I mean, it just seems unusual that you would have 3 different individuals bleeding or their blood present inside a vehicle in that kind of a location. That, to me, is the significance.
May I have a moment, Your Honor? Mr. Sims, Mr. Scheck never asked you about 293. 293, you're aware of the history of 293?
Sorry, I didn't hear that. My apologies.
Asked about 293.
Yes, he asked me about that, and I discussed a little bit about how the carpet was cut out and then later sampled.
Okay. And that was done at the earlier date rather than the later date. Is that your recollection?
My understanding is the carpet was cut out at the earlier date.
And the types that you found on the carpet are consistent with, are the types that you found on the carpet consistent with what you detect as the possible presence of Nicole Brown on 303, 304, and 305?
Are they consistent? Yes. In other words, her type that was found on that sample is consistent also with what was seen in the Bronco console.
And finally, I'm going to ask you a question about 31 and 30 and 303 and 304 and 305. A chance to look at those results? Are those results consistent with Mr. Simpson having injured himself during the brutal murder of Nicole Brown and Ronald Goldman, returning to his car, that Bronco, with a right-handed glove that bore their blood commingled with his blood from his injured left hand, and somehow that item having come in contact with the console?
Objection calls for speculation.
Sustained. Foundation.
I'm going to ask you a question then about whether, the question is, are your results consistent with the following scenario? You know what Mr.
Haven't heard the question yet.
You're familiar with the testimony that Mr. Simpson had a cut on his left hand.
Well, I mentioned that I hadn't heard Dr. Bodden specifically talk about that. I'm aware from other issues in this case about the cut on the hand.
On his left hand.
On the left hand, yes.
You know what his DQ alpha type is.
Yes,
You know what his RFLP type is from all the tests that we've done.
yes,
And you're familiar with the fact that the victims in this case, their reference samples were provided to you for typing.
yes,
Okay. You're familiar with your typing results from the glove, number 9.
yes,
Okay.
Oral.
You're familiar with where all the stains were found on the console. We've just had the photo board up there. Is that right?
yes,
Are the PCR and RFLP results that you produced, your lab produced from the console, are they consistent with Mr. Simpson having injured himself while brutally murdering Nicole Brown and Ronald Goldman?
No foundation.
Sustained.
Are they consistent with Mr. Simpson having injured himself at or about the time someone brutally murdered Ronald Goldman?
Sustained.
Objection and move to
Sustained.
strike. Ask for an
Sustained.
instruction if he persists.
Mr. Sims, let's go back to the same question about the console. Are all of your console DNA test results consistent with the glove, item number 9, having Mr. Simpson's blood on it, that glove being in the Bronco, coming into, and having the victim's blood on it as well, and that glove coming into contact with the console and transferring portions of all 3 participants' blood onto the console?
Objection. No foundation.
Sustained.
Calls for speculation.
Mr. Sims? Mr. Sims, you know what the glove results that your lab produced suggest a mixture consistent with Mr. Goldman, Mr. Simpson, and Ms. Brown. Is that correct?
Beyond the scope.
Overruled.
Yes.
I want you to assume hypothetically that that glove was brought into that console or into that Bronco, and that glove transferred some of the blood from the glove onto the
Cause for
console.
speculation.
All right, ladies and gentlemen, we're going to take our recess for the morning session at this time. Remember, all my admonitions to you, don't discuss the case amongst yourselves, form any opinions about the case, conduct any deliberations till the matter has been submitted to you. Do not allow anybody to communicate with you with regard to the case as far as the jury is concerned, and counsel will stand in recess until 1 o'clock. Mr. Sims, you may step down. You're ordered to come back at 1 o'clock. All right, we'll stand in recess. The jury is not present. Counsel, when we adjourned, Mr. Sims was on the stand, and Mr. Harmon was asking a hypothetical question regarding the glove results, number 9, being consistent with 304, 303, and 305, and that's where we were.
Your Honor, I think that I would object to any further questions along this lines in terms of Mr. Harmon was asking a series of hypotheticals that plainly go far beyond what's permitted. We're talking about brutal murders and everything else, and not tied to what was raised on the cross-examination, which all I brought out is that it's consistent with that he can't tell what blood was deposited when. That's all I did. I think this is way beyond the scope, and I think it's reached a point now after all these different questions where we're way into argument. Hopefully we'll argue this case soon, but I think that these hypotheticals are improper.
Well, frankly, I thought that after he got this answer, well, when you enter the point now where you're talking about 3 different people's blood on a console in a vehicle, I mean, forensically, that seems very significant to me.
You know, Your Honor,
I mean, it just
I
seems...
reconsidered that over the lunch hour.
I mean, it just seems unusual that you would have 3 different individuals bleeding while there's blood present inside a vehicle in that kind of a location. I thought that was going to be the last question and answer.
It probably should have been. I have 2 more, and they have nothing to do with my hypothetical.
You're going to withdraw the hypothetical?
Yes, Your Honor.
Bless you. All right, let's have the jury.
Your Honor, before we call the jury back, I just did want to put on the record that I was down here over the noon hour and did bring the materials, or at least parts of the materials that we have for defense to see, and they wanted to go out and have lunch. I am now leaving to do some other business that we will be prepared to
Which materials did you bring down?
I brought down the test impressions that were taken on August the 21st, and I brought down certain of the raw materials that are going to be placed on boards, photographs, including photographs of the jeans, photographs of the Bundy walkway that were taken on June the 13th, plus those that were most recently taken, the black and white photographs of various abnormalities in the tiles, and some other photographic materials that would be used to be placed and mounted on boards for the purposes of evidence that would be presented presumably tomorrow morning.
Your Honor,
Mr. Scheck?
you have to, I thought that we had an understanding when Mr. Harmon and Mr. Clark were present at the bench that I reiterated the request, which I thought the court granted yesterday, that we would get an opportunity to look at the test impressions, the blown-up photographs, the shirt, and the jeans at one location. I raised this with Mr. Goldberg earlier. I brought it up with the court. I thought the court said that that could be arranged either in the courthouse or at the lab. I went back to Mr. Goldberg. I said, communicated what Your Honor had said to us. I asked him to make that arrangement. He began to do so. Then Ms. Clark turned to him and said, just show him the test impressions. That's it. And then I said, well, Ms. Clark, it's not my understanding of what the judge just indicated and what he previously ordered. And she said, just give him the test impressions, that's it. And Mr. Scheck, I'm not talking to you. Don't even talk to me. I don't talk to you. That's the way this woman works. And she's ordered him to do that. Now, he came down here at 1:45 as we're running downstairs. He pulls out a big packet and he says, take a look at this one, take a look at this one, take a look at this one. And I say, we're going downstairs to eat lunch. Right now, we can't do it. Mr. Morton just arrived. A Federal Express package just came in. Now, you know, I've already made my arguments about an opportunity to look at it. We have to have an opportunity to look at the data that they're going to put on, and we're taking the afternoon off because their witnesses just arrived, and it's a civilized, scientific way to proceed. I've requested an opportunity to talk to the witnesses and just make this simple arrangement. It should take an hour or two to show us the data. I think that's what's required, and it's civilized, and I just ask that that be done. And if Mr. Goldberg's going to run out the door and we won't be able to see him later in the day and make arrangements for this, and we won't be able to get a hold of him in the office, I think that's wrong.
Your Honor, my understanding of the court's order yesterday, and I think it was pretty clear, is that we were supposed to, over the noon recess, have the test impressions from the 13th and the 31st, excuse me, from the 21st and the 31st in court. We learned that the 21st impressions have been mailed to the court. So I don't know. Excuse me, the 31st impressions from the jeans and the shirt have been mailed to the court. But I wanted to try to satisfy the court's order by being down here at over the noon recess, and that's what I was trying to do. If counsel didn't have an opportunity to look at them at that time, whether it's legitimate or illegitimate, doesn't make any difference to me. We will try to accommodate them at some later point. The point is that had they wanted to look at them over the noon recess, they could have done so, and I was trying to fulfill the court's order. No one recalls anything other than Mr. Scheck about the court having revisited this issue and now placed an additional requirement on the people that we are responsible for assembling the jeans, the shirt, the test impressions simultaneously at the same place, at the same location. That's a logistical problem that's difficult for us to do that the court did not require us to do. Because that would mean...
Well, Mr. Goldberg, here's our choice. Mr. Morton's here, Mr. Scheck is here, the impressions are here. It would take us an hour to take this evidence after the jury's been excused, put it in the jury room, let them look at it, and then we can proceed.
Right.
That's the orderly way to do this.
The only problem would be getting the jeans and the shirt here. That we'd have to do that, and that would be difficult.
But I suspect it's less than a mile away.
Well, it's a Piper Tech.
Less than a mile away.
Right, but the point is that it needs to be checked out, and I'm not sure that the jury room is really the appropriate environment to be looking at those jeans. I'm not sure that would be acceptable to Mr. Morton as a forensic scientist.
Well, given the fact that I want this done now, that's where it's going to be.
Okay.
I don't want to delay this trial anymore. Mr. Morton's here. The impressions are apparently here. I'm certain Mrs. Robertson could find somebody to call over at LAPD to get Detective Van Adder to check those items out and get them over here. Let's let them look at it. Maybe we can proceed with this testimony today.
We won't be able to, because they just arrived. I saw them. They've gone out to Bundy to re-examine the scene and look at the various defects in the tiles. And they will, however, be ready first thing in the morning.
All right, so you're not ready to present this at this point in any event, so because your witnesses are in West LA.
Correct.
Your Honor, we've also communicated longstanding, we'd like an opportunity to discuss with the witnesses what it is, because just looking at the test impressions and the markings and the pictures, it's hard to link it up if they could provide us with that opportunity.
All right.
Since
I'll let Ms. Clark do that. Evidently, she's going to be putting on these witnesses, and our policies, we always allow the witnesses to decide on their own. We do not make any suggestion one way or the other.
All right.
Can I just also say, I don't think it's necessary for the record. In response to Mr. Scheck's contentions about Ms. Clark's statements, she was simply communicating to me that her recollection of the court's orders were not the same as Mr. Scheck, and that the court did not modify its previous order. For the record, you know, we've tried to get along with all the attorneys as amicably as we can.
Yes.
I think the defense has done so as well. There appears to be a little bit of perhaps it's a cultural clash between the California and New York styles. I don't know what it is. But
he was right about Meshuggah.
We have had a little bit of difficulty at times with Mr. Scheck and Mr. Neufeld, and it is simply easier for us to deal with many things on the record than try to sort them out informally. We've had some trouble doing it.
Well, the court's interest is getting this testimony presented tomorrow. And
I
if that
understand
means-
it, and that is our interest as
right.
well. I just wanted to say that we have had a little bit of a difficulty, and we're trying to smooth it out to the extent that we can.
All right, Mrs. Robertson, excuse me. Would you contact either Detective Bainat or Detective Lang and see if we can get those two items, the shirt, Mr. Goldman's shirt, Mr. Goldman's pants, checked out and brought over here, please?
Good afternoon, Your Honor. I'm from California, and so I can understand this.
No, we're not discussing this anymore.
This is something else I want to bring out.
No.
If he's going to leave, it has to do with one other thing, so we're going to delay the trial.
What is that?
We need him here if we're going to talk about that video. We have some objections to the video. He's not going to be here. It's his video, isn't it?
Handle it.
All right, Ms. Clark will
All right.
handle it.
I just want to make sure he's available.
Okay.
All right.
All right. So everything's clear. The court has received two packages from the FBI. Mr. Burden, my research attorney, is cataloging those items, and then we'll make those available for inspection to counsel. Also, we've received from NBC what appears to be a sealed package of videotapes in response to our discussions yesterday. All right. Also, excuse me. All right. As soon as Mrs. Robertson logs those in, we'll have the opportunity to display those to counsel. The videotapes from NBC. Also, while we were still in recess, Mr. Neufeld advised the court that he had advised the prosecution that apparently there's some objection you're going to withdraw, Mr. Neufeld.
Yes, sir.
Good afternoon.
Good afternoon. What we are prepared to do, Your Honor, is withdraw the objection that the RFLP results for the combination 303, 304, and 305 stains need to be presented in conjunction with the statistic. And the failure to do so is the objection that we are now withdrawing. But it should be very clear, though, that we're not saying that authorizes them to argue to the jury that the true numbers for the significance of that mixture are the solo contributor stains that exist elsewhere, which have been typed as consistent either with Mr. Goldman.
I don't think
or
they
Mr.
would do
Simpson.
that.
Right.
Excuse me, Your Honor, I think that's perfectly proper argument if the jury decides in the context of this case that those two stains did come from those people, and there's other information within this case that will allow them to do that. I think the court, upon reflection, will see that if they decide that, and if that information is contained
counsel.
elsewhere, then that's a proper point to make to them, and that's a proper conclusion for them to draw.
You're on two things. Number one, we suggested doing this to save a great deal of time. They were going to have somebody come in from Great Britain. We would then have to have Dr. Shields come in to respond to that issue. It looks to me that from the expressions on the jurors' faces now, I mean, whoever has any more witnesses gets these cold stares from the jury. And we're trying to avoid the continuation of that problem. All we're simply saying is they would be precluded from arguing solo frequencies for the other mixtures, and that's why the court made the initial ruling, and that's why Bruce Weir came in here and offered different frequencies for mixtures than the frequencies that are given for solo stains. So that's been the approach to mixtures throughout this entire proceeding. It would be a distortion of that reality should they be permitted to then argue something completely different for this mixture, which they're not allowed to argue for any of the other mixtures. It just doesn't make any sense.
Just final response. Reality has no reason to be mentioned in any of these arguments. These are legal arguments designed to create a reality, okay? We are not conceding that there's any validity to limiting our argument because they're willing to shorten the trial. Whatever you feel is appropriate argument at that time, you'll have to decide that, Your Honor. We have not agreed to anything except if they withdraw their objection, we will not call a statistician. There's no quid pro quo for that, Your Honor. That's their decision. We're happy they want to shorten the trial. But we have not agreed to any concession on any other point. And I think the court will see in the context of the argument.
The problem I have, though, counsel, is that the original proffer to this evidence, this RFLP, was not to offer any statistics, merely to say that it is consistent with the PCR test. That was the offer that I was given, and that was the assumption that I was under when I allowed this evidence.
And nothing I've said, I think contravenes that or...
I agree, so far.
Or undermines that. But my point is, I mean, listen to the cross-examination. I was going to ask you to reconsider your ruling in light of the fact that they have conceded by their cross-examination that part of that RFLP pattern is Mr. Simpson's blood. Well, then who else, what other pattern is left there? And if there's information in this record that this jury can use to evaluate how frequently that fainter pattern, which when you subtract Mr. Simpson's out is Mr. Goldman's, then I think not only is it permissible for them to do that, that Ms. Clark can ask them to do that. She may not want to. My only point, because we're not arguing the case now, is to say we're not conceding any issue in light of what you know, that they don't want to see another statistician here. We're delighted about that as well.
All right, I understand that, but you should understand that the court's already made a ruling in this area.
No,
All right,
we remember that.
okay, all right. Let's have the jury and let's finish Mr. Sims.
So we will not call a statistician.
All right,
Let me indicate while the jury's coming out, Your Honor, we've received, these are other charts that were mailed to us from Agent Diedrich, and I want the defense to know that they're here. I want to show it to them as soon as we recess today.
all right. Let's finish Mr. Sims, and then we'll see where we are at that point. What do you have after Sims, by the way?
The video,
And what after that? Diedrich?
that's it. Well, but that would be
Yeah, they'll have rested twice, and
We're going to ask the court to rest subject to, also, Your Honor, we have sent a letter to the defense requesting the Stockdale tape because we have declaration from the answering machine company that they no longer have any copy. All rise.
please be seated. All right, let the record reflect that we've been rejoined by all the members of our jury panel. Good afternoon, ladies and gentlemen. Mr. Gary Sims is again on the witness stand undergoing redirect examination by Mr. Harmon. And Mr. Harmon, you may continue.
Good afternoon, ladies and gentlemen. Mr. Sims, just one last point, a couple of questions. Based on the combination of your RFLP and PCR results from 303, 304, and 305, how would you quantify the amount of DNA which produced results consistent with Nicole Brown?
The amount of DNA for that particular component of the mixture would be what I would describe as a trace level of DNA.
Okay. And you recall Mr. Scheck asked you about eliminating or talking about how many different deposits there would have to be or there might be to account for the console results from 303, 304, and 305. Do you recall that question?
Yes.
And you said it's possible that there could be more than one deposit that could have produced the combined results that you saw in this case?
Yes.
Now, in light of the trace amount of DNA that you've described is consistent with the results that are consistent with Nicole Brown, you with me so far?
Yes.
And in light of the fact that you found 3 such results, what series of events would have to have happened in order to have, and assuming that Mr. Simpson's blood was there previous to that in all three places?
Okay.
Okay. Would you describe the series of events that would have to have occurred to account for the trace amounts from Nicole Brown and the substrate controls from those three samples testing clean?
Calls for speculation, vague.
Sustain.
Can you describe the series of results? Keep my last question in mind. Can you describe the series of results which would have to have occurred in light of the trace amounts of DNA that are consistent with Nicole Brown?
Calls for speculation again.
Sustain.
In order for you to have seen the results that you saw, which include Mr. Simpson's DQ alpha type, and by the way, how would you describe the amount of DNA which produced Mr. Simpson's types as opposed to the trace amounts that produced results consistent with Ms. Brown?
PCR or the RFFP?
In general, on the three console stains, 303, 304, and 305.
Well, I would describe it that there was significantly more DNA consistent with Mr. Simpson than there was with Nicole Brown Simpson's sample.
Okay? Now, in order for you to have seen the results that you had, the greater amount of DNA consistent with Mr. Simpson's type and the trace amount of DNA consistent with Ms. Brown's type, and in order for there to have been two deposits, one of Mr. Simpson and then at least one more with a trace amount of Nicole Brown's, would you have to have had that trace amount deposited on all three separate stains and not on the substrate controls?
Yes.
Substrate ejection calls for speculation and is mixing two different...
Thanks, Mr. Sims. I have no further questions.
Mr. Scheck.
The answer was yes.
The answer was yes. Okay. Mr. Sims, you don't know who was in the car, who was in the Bronco in the early morning hours of June 13th.
The early morning hours of June 30th? No, I don't know.
Right. You don't know the identities of the contributors to the mixture on the steering wheel.
That's beyond the scope.
No, I don't know.
Has anybody sent you DNA exemplars from police officers to type?
That's beyond the scope.
Sustain.
You don't know who went into the Bronco between June 14th and August 26th.
I don't know.
Thank you. And
Thank you.
Mr. Harmon? But he's subject to recall for the reasons we stated.
No further questions.
All right, Mr. Sims.
Excuse me.
Thank you. Mr. Sims, again, thank you, sir.
Thank you, Your Honor.
Ms. Clark,
We have our next witness ready, Your Honor, but I think the defense...
we need to preview something? All right. All right, ladies and gentlemen, let me ask you to step back into the jury room. I need to preview something before we present the next witness. All right, I take it, Ms. Clark, the next offer from the people is the statement from Thano Paratus under 1202?
Yes.
All right. let's see the edited.
Yeah, before you see it, I think it would help the court if you knew in advance, because I just got to see a little while ago what some of my concerns are, so you can, when you're looking at the tapes, you can see whether or not they're there. I just think it helps you in deciding this thing rather quickly.
You want to pre-object before I see it? All right.
Yeah, or at least to tell you the things.
Well,
which
what
think
should
is-
I be looking for?
Okay, thank you. Your Honor, the problem is I don't believe that they followed your instructions of yesterday. Number one, right off the bat, they start referring to a demonstration that he wants to show, although he doesn't actually show most of the demonstration. He refers to that he's about to. Number two, he then orally describes the experiment that he did, not with Mr. Simpson's blood, but an experiment that he did sometime between the time he drew Mr. Simpson's blood and the time that this tape is made on July 27th. You said no reference to any experiments are to be included in this tape. It's simple impeachment on the issue of the 8 cc's. He goes through a description of the experiment he conducted in his own infirmary 8 months after the incident to help convince him of the error of his ways, that his testimony at the grand jury and preliminary hearing were wrong. So they didn't follow your instructions with regard to that either. Number three, on the tape they will refer to the 6.5 cc result that he achieved when he completed his own experiment. Again, referring to the very experiment that he's not allowed to refer to, given your instructions yesterday. Number four, there's still a ton of extraneous references on this tape which has absolutely nothing to do with the impeachment. Again, contrary to your specific instruction yesterday. Number five, you still have Mr. Goldberg on there as an unsworn witness, and what makes it much worse and more problematic is he's paraphrasing the grand jury and preliminary hearing testimony, but not quoting it accurately. In fact, he's misstating it at least twice, and I can point those out as well, and you'll see when he mentions it here, if you look at your transcript, the disparity will be quite obvious. And finally, there's two critical things missing from the tape. One is there's no explanation as to when he realized that his testimony at the preliminary hearing and grand jury were wrong. Thus, as a result of the way the tape is currently edited, the jurors will be free to speculate that it was right after we got off the witness stand, for instance, at the preliminary hearing in July of 1994, that he realized he was wrong, when in fact, even if you give his false statement about learning from a friend of a friend of a friend who was watching the trial on television, given that statement, he didn't realize he was wrong until after the trial began, and he knew what the defendant's theory of the case was, and he had heard or felt that perhaps the testimony he gave would screw the prosecution or hurt the prosecution. It's only then that he began to reassess what he had done. The way it exists right now is a suggestion that it could have happened the day after he testified. So that key element is missing. And finally, there's another segment on the tape where Mr. Goldberg asks him a question, and he mouths the words, "I don't remember," without actually uttering the words. I don't know if you recall that when you saw the tape yesterday. And to me, Your Honor, and to other people I've discussed it with, there's a suggestion that during this, prepping session that occurred between Mr. Goldberg and the witness before the tape actually started running, that certain things were scripted or prepared. And now Mr. Goldberg is asking him a question, and he's going, "I don't remember," although he doesn't actually say it, because he doesn't want to say it so it can be heard on the tape. He just mouths the words, and that too, seems to undermine his own credibility, and that's missing from this tape. But I'd just like you to look for those things when you see it, and I think the key thing is they simply didn't follow your instructions as to what had to be taken out.
Wasn't it your instruction to take out the experiment where he measures? We did.
Let's see the tape.
Photographer Teresa Ramirez, and this is going to be a videotaped interview, Thano, Thano, Paredes, P-E-R-A-T-I-S, which is July 27, 1995, and the time now is approximately 3:48 p.m. Again, this is just a backup tape for the videotape that we're going to be taping.
The tape reads 336.
Okay, tape reads on video 336.
Basically, what I wanted to do is just ask you about 3 statements that you made at the preliminary hearing, and we'll go through those one at a time. And the reason we're videotaping, as I said before, is because there was a certain demonstration that you had wanted to show us. We thought it would be better if we had a videotape than if we just did it with an audio tape or some other way. And if you want to stop at any time where you feel uncomfortable, for any reason, just let us know. And I know that you've just been through a traumatic incident in terms of your health condition. The first thing that I wanted to know about was the statement in the preliminary hearing to the effect of when you were asked how much blood did you withdraw from Mr. Simpson, where you said approximately 8 cc's.
Yeah,
Okay.
that was an estimation,
All right.
because that's what we all think we draw at that time.
When you say we, you mean,
The nurses.
and when you say that you think that you usually draw 8 cc's, that's based upon what?
Based upon what the vat container tube pulls out of the yarn.
Do you regularly measure how much you've drawn from a person after you've drawn the blood?
No.
Have you ever done it on any previous occasion prior to when Mr. Simpson came in?
Oh, I draw blood quite often, but not this sort.
That you don't measure it?
No, we never measure any blood.
And when you said not the sort, what do you mean by that?
Well, usually I draw blood for people that are arrested drug driving.
Okay.
And that's a different tube and different method. And just draw it, and that's the officer, and that's it.
So was there something about this statement that I just mentioned to you where you were asked this question, how much blood did you withdraw from Mr. Simpson? You said approximately 8 cc's. And then you went on and you were asked, when you say approximately, did you not measure the amount? You said, well, it could have been 7.9 or it could have been 8.1. At some point, did you realize that that wasn't correct?
Not that day. Started measuring 1 cc was put in the test tube, and I kept doing it until I got 8 cc's. When I saw how much 8 cc's was in the test tube, that was more than I drew. So I took another test tube and kept putting in water until it looked approximately as to what I had drawn. I measured that, and that was about 6.5 cc's. So I estimate that that's what I really had drawn. That's approximately 8 cc's right there. That was more than I drew.
And how did you know that?
Because it looks like it was more than I drew. So what I drew was approximately down to this point. There you go. Which should be 6.5 cc's.
So after you've done this, what conclusion did you come to?
I came to the conclusion that I was wrong in the statement I made, that I didn't draw 8 cc's, that I drew about 6 to 6.5.
Is that an approximation?
That's still an approximation.
Yeah. There was another statement that I wanted to ask you about that also took place at the preliminary hearing. Let me just get hold of that. And that was the statement that said, I just looked at the syringe and it looked at about 8 cc's.
That was
Remember
a
that?
statement, which I should have made. I looked at it, I should have said it looked like it was enough, which it was enough.
Yeah.
8 cc's, I just I was wrong in that 8 cc's altogether.
Can you show us what you did do in terms of looking at the syringe after the blood, or when the blood was being drawn? Mr. Simpson.
And here, okay, the blood was pulled out. I pulled it out. I saw that. What it was, I squirted the blood into me. Trash. I just looked at the syringe.
Okay,
I didn't turn it over.
there is a part of the syringe that was
Well,
calibrated.
yeah, but I didn't, we just, unless you have a reason to look at those calibrations for dosage purposes, we just don't do it. At least I don't know how many nurses do. I've asked nurses, hey, do you know exactly how much blood you've drawn? No, about 8 cc's. Now, you want to make a bet and we'll check next time? Nobody wants to take the bet, take me on that bet.
So where did the figure of a 7.9, it could have been 7.9 or it could have been 8.1 come here?
It was an approximation. Even what I did here, okay, 6.5, but it could be 6.4, it could be 6.6. You can't, this is not exact. None of this stuff is exact. If you have an order exactly, then you're very careful. We don't have any special orders of how much you draw. If somebody should request a certain amount of blood, then I would be extremely careful to draw that much. So far, I've never had a request like that.
Take blood with a syringe, a hypodermic syringe like the one that...
Most of the time we use them, I myself, most of the time I use the vacuum. But when I get someone as big as OJ, big arms, big muscles, I myself have found I can control it better when I use a syringe. You just go in, I can be able to get my finger on that vein and go bang without a problem. Other times, I can do a lot better just by using the other, you for example. Without a tourniquet, I could just go bing on you.
Yeah, that's something there. Now, when you say that some usually use the vacutainer, what's that?
The vacutainer is, this is the vacutainer.
Oh, okay.
And what you do, you put a, I don't have one of those now, but you put it has a needle on this end too. You screw it in here. Then you put this in here, you inject into the, and then when you're in the vein, you push on this, and it just sucks the blood through.
Okay, that's based on the vacuum that's in the tube.
Yeah, on this now, I'm not what happened because if there were any air in there, we'll just suck it out, that's all. But this is made for a different type of thing. It usually has a needle on the other end. You just inject the needle.
How often do you use a syringe as opposed to a vacutainer?
Oh, not very often. It's just when I get a big person. And put it like I make an evaluation of the arm, and that's you get in the habit to do right away. You look at the other one, I look at him, I have no trouble. If he came in for anything, I'd immediately go for a vein right like that. I saw his arms, and they had veins like that. Oh, these never hurt here. And I just brought their big bang and I put anything on him, because those are nice big veins. I used to have those until I had ruined on this side. When you get something like with OJ, his arms are pretty big. I've had other big people like that. And I usually just find it's a little easier, not only for me, but for the patient. You don't have to dig around, you hit them, and that's it. And I haven't had any complaints of knowledge or anything.
Did you have any problems when you were drawing blood from the defendant?
No. I just, at this one certain point, as I was pulling, the bevel, the needle hit the wall of the vein, and that's when it stopped. And so you could either turn your syringe and draw more. But at this point, it appeared like I had enough. So that was it, I just stopped it.
Is that when you looked at the syringe at that point where the needle hit the wall?
Well, I was watching the needle hit the wall, it's the only reason it would stop.
Oh.
It was the reason the blood would stop. And I figured, well, that's enough. In fact, every time I draw blood and I reach that point, it just, well, you've got enough blood, there's no point in going any further. You can turn your needle and continue drawing, but there's a slightest, in my opinion, there's the slightest chance that you may damage the wall. I don't want to take that chance.
But when in relationship to the blood stopping, was it that you looked at the syringe?
Immediately.
Oh, that was when it was? But you looked at the part that's opposite from...
Yeah, the calibrations were on the bottom.
Okay. All right.
Because again, that's not what we go by.
You're going by what?
No, we just go, it seems like you go by instinct. But I've never had a case where we never had enough blood.
You know, where they came back and said you didn't draw enough blood.
Yeah, I've never had a case where it says, we need more. I don't know any case, and if there has been, I don't know any, in our department, I don't know anything about it.
Okay. I think that's about it, unless you have something else you want to speak. All right. Well, thanks a lot.
Well, you're sure welcome.
I think the videotape indicates that we obeyed the court's orders in terms of the excisions requested. There is no experiment performed by Mr. Paradas. The only reference to a demonstration he makes is an eyeball estimate of how much 8 cc's is, and that was more than he did, and that it looks more like it's 6.5. That's no more an experiment than having a witness testify, well, he stood about from here to there. Well, would you get down and show us how far he stood? Okay, you get down, well, no, it's a little closer. Okay, tell me when to stop moving in the eyewitness identification cases. You call that an experiment? Or is that an experiment that requires the kind of foundation and cross-examination that Mr. Neufeld implies? I think not. This is a very simple, non-rocket science sort of thing. This is a man who's... Notice what I didn't say. This is a man who's looking at the test tube and eyeballing how much he thinks it is, for what it's worth. All of the tape goes to the aspect of how much blood he took and the approximation that he made of that and the unreliability of any number attached to the amount that was contained in the test tube by virtue of the means by which he does it and by virtue of the fact that he is not aiming for any particular amount. It's not a formal thing. The question he has to answer is, did I get enough? He got enough. The method he used by using the syringe, drawing the blood, it's not with a vacuum, so that means that he'll draw until he thinks he's got enough. I mean, that's really what it comes down to. He's not looking at the calibrated side of it. In this particular case, he hit a vein and it stopped and he figured that's enough and it's not worth trying to get more, that I might injure Mr. Simpson, so I'll stop here. And that was all he was trying to do. And I think that the entirety of the tape that's what it makes clear. But to call an eyeball of an estimated amount of water in a test tube an experiment is really dignifying it way beyond the realm of reality there. And the aspect, I think, of the tape that the court wanted us to take out, we did. I thought we did. Is there more that the court would like us to excise?
I'll hear the comments from Mr. Neufeld.
Right, very specifically, the problem is not simply doing any kind of demonstration on the tape. He is describing orally verbally a demonstration that he conducted sometime in February of 1995. And that's what he's explaining. Even when he's not taking the syringe out now and doing the 1 cc withdrawals, he is verbally explaining it to the camera. And that experiment itself does not substantially replicate what happened with Mr. Simpson back on June 13th of 1994. So both, I thought your ruling was very clear that no reference to either experiment could be included in this tape, and it's still there. There's even a reference to a demo I'm about to show you on this point. There's the reference to the 6.5 result of the experiment, and he's only holding this up after he completes the experiment. It's not just a description of what he remembers seeing. Now it would be 13 months earlier, all right, back in June, from June of 1994 to July 27th, 1995. It's not just that. And finally, Your Honor, one of the interesting things is what Mr. Goldberg does is he dissects the Q's and A's from the preliminary hearing. In the preliminary hearing, when he's asked, when you say approximately, the answer is I withdrew approximately 8 cc's. And the question then is, when you say approximately, you did not measure the amount? Answer, well, it could have been 7.9 or it could have been 8.1. I just looked at the syringe and it looked at about 8 cc's. When Mr. Goldberg is asking him the Q&A on the tape, he doesn't include the I just looked at the syringe and it looked at about 8 cc's in conjunction with, well, it could have been 7.9 or it could have been 8.1. In fact, what he's saying is, when he says it could have been 7.9 or 8.1, I knew this because I looked at the syringe and it was about 8 cc's. By separating those statements, which is not the way it is in the preliminary hearing, it distorts the answer of the witness, where the witness is quite plainly, unequivocally, explaining under oath at a preliminary hearing that the reason he knows it's between 7.9 and 8.1 is because he looked at the syringe and it looked at about 8 cc's. And by separating that, you really paint a very distorted picture for the jury. And then, Your Honor, as I said before, it's missing those two very, very important elements, most important of which, of course, is when it first dawned on him that all of his testimony was wrong. That is a critical fact for the jury to assess.
But I thought that we agree that all of that, your objection yesterday was that there was a lot of extraneous material in there, including the telephone calls from friends of friends of friends who told him that he had done all these silly things and the motivations for him having done this. I thought we agreed that that was extraneous hearsay.
No, what I said about the motivation, Your Honor, is that he lied about that. That what he told Mr. Blazer and what he told Joel and Demetrius when we were in his infirmary on April 11th is that he was personally watching the trial on television using the same television that he showed us in the infirmary that day, which was glued to the channel that was covering the trial while we were actually there in the infirmary, that he had watched Mr. Cochran give his opening statement, and it was when Mr. Cochran gave his opening statement that he realized, oh my goodness, my testimony at these hearings may have screwed the prosecution, and I ought to reconsider.
The fact that Mr. Parada says something on the tape that you feel you can rebut, that's for another decision. This is not the decision I have to make now.
No, but in terms of impeaching him, they want to impeach his earlier statement. The jury can't have half a glass on this. They are actually misrepresenting then the reality of this witness's statement by simply suggesting or allowing the jury to speculate. And that's the more dangerous thing here, Your Honor, that the jury could speculate that it was immediately after his preliminary hearing, more than a year ago, that it dawned on him that he had made this mistake, and so he went back and rethought about it. When we know, even if we take him at his word, that at best, it's sometime in February of 1995 after this trial has already begun. And there's a big difference between somebody innocently coming to the conclusion that he made a mistake and that his testimony was wrong a few days after he gave it, as opposed to here what he's saying is it came to me for the first time when he has, in fact, a motive to lie, if you will, only after Mr. Simpson's defense has been articulated to the jury on television. There's a huge difference between those two. So they'd have to include that.
You think they have to include?
I'm asking that portion be included, and when then need be, we will rebut it on serve rebuttal. I'm also asking that all the other portions of the tape, though, which are extraneous, be redacted or deleted from an edited version. But you can't really misrepresent or allow them to speculate as to when this dawned upon him, when it's very, very clear that no matter what the source of the dawning was, the timing is not in dispute. And the timing is not until after Mr. Cochran gave his opening statement.
All right, Ms. Martinez, I'd like to see, can you roll me up the point where Mr. Parada says that he was wrong, it was probably 6 to 6.5, and he shows the tube. That's about the second. There's 4 series of answers that he gives with regards to this issue. And while we're waiting for that, Mrs. Robertson, did you get in touch with the detectives?
The detectives were out in Philly, Your Honor. Mr. Matheson was packaging the items and bringing them over.
Perfect.
That was more than I drew.
And how did you know that?
Because it looks like it was more than I drew. So what I drew was approximately down to this point.
There you go.
Which should be 6.5 cc's.
So,
Before that, Your
About 30 seconds before that. About 30 seconds before.
the split conclusion that you come to.
I came to the conclusion I was wrong in the statement I made, that I didn't draw cc's, that I drew about 6 to 6.5.
Is that an approximation?
That's still an approximation.
Yeah. There was another statement that I wanted to ask
Can you roll back, I'm
about
sorry, can you roll
that
back about
also-
30 seconds before that?
So, after you've done this, what conclusion did you come to?
I came to the
I need
conclusion
30 seconds before that.
So I estimate that that's what I really had drawn. That's approximately 8 cc's right there. That was more than I drew.
And how did you know that?
Because it looks like it was more than I drew. So what I drew was approximately down to this point.
There you go.
Which should be 6.5 cc's.
So, after you've done this, what conclusion did you come to?
I came to the conclusion I was wrong in the statement I made, that I didn't draw 8 cc's, that I drew about 6 to 6.5.
Is that an approximation?
That's still an approximation.
Yeah. There was another statement that I wanted to ask you about that also took place at the preliminary hearing. Let me just get hold of that. And that was the statement that said, I just looked at the syringe and it looked at about 8 cc's.
That was
Remember
a
that?
statement. I looked at it, I should have said it looked like it was enough, which it was enough. 8 cc's, I was wrong in that 8 cc's altogether.
Can you show us what you did do in terms of looking at the syringe after the blood? Or when the blood
All right,
was
thank you,
being
Ms.
drawn?
Martinez. Well, certainly not a presentation designed to make this easy. No, you have to admit that it does jump around.
Well,
Yeah. All right, keeping in mind the limited use of this particular item, I'm going to allow its use. So the objection will be overruled.
Sorry, in its current form?
Correct form.
Well, what about then a concern, Your Honor, which I haven't raised yet, pursuant to 356 of the Evidence Code, that I would like to then include certain segments in this?
Absolutely.
Well, the segments I would want them to include would be the segments where he...
356 would allow you to do that if you want.
Okay.
Why not let it put it back in
No.
there? I mean, this is kind of like a game. We were happy to have it in to begin with. If Mr. Neufeld wants it. He complained about it yesterday. We took it out.
And we stopped and we went through all this trouble, and now I've had to watch it 3 times. You're right. But if there are items that aren't there that they want to put in under 356 as a matter of tactics, they're entitled to do that. I agree with you. This doesn't make sense, but let's proceed.
Well, we can put it back in. We have the original. We can put it back in so that we can play the whole thing for the jury. I mean, we do it this way. It looks like the people are trying to hide something. And the unfairness of that is we were trying to show it to begin with and cut it out of their request. So I'm happy to put it back in. I don't think it's fair to create that impression.
Well, that won't be allowed to be argued. All right, let's have the jurors, please.
After we play the tape, then they're going to come back and play their excerpt, and whether they argue it or not, it's going to look like we were trying to hide something. People are being penalized for their objection that they're withdrawing.
I didn't hear them withdraw the objection. They said under 356, do they have the opportunity to play portions they feel are favorable to them? The answer to that is yes.
But, well, I agree, except that you understand the excision was made at their request.
I understand that.
Now they're playing an excerpt that they asked to be taken out, creating the impression in front of the jury that we're hiding something.
Do you want to withdraw the exhibit? That'll save us all the trouble.
And then penalize the people altogether because they changed their minds?
I'm not penalizing you, counsel. I'm letting you enter your evidence. Just step back in the jury room, please. All right, the jury is withdrawn. Have a seat, ladies and gentlemen. Ms. Clark, for you to suggest that this court is penalizing you, I think borders on contumacious conduct on your part. That's the second time you've done that. You're warned in no uncertain terms. Do you understand me?
I do. I meant nothing like
Let's
that.
have the jury, please. Ladies and gentlemen, please be seated. All right, let the record reflect that we've been rejoined by all the members of our jury panel. Sorry about that start and stop there. Ladies and gentlemen, the next item that will be presented to you will be People's Exhibit 615. It is a videotape of a statement. It is going to be allowed, I'm going to allow its viewing, the excerpts from this videotape for a limited purpose. It is presented to you for the limited purpose of evaluating the credibility of the witness that it involves. All right? Ms. Clark, you may present 615.
Well, I'm sorry, it's my understanding they're calling a witness.
Well,
Thank you.
when we get to the videotape.
Thank you. People call Mr. Opler.
Raise your right hand, please. You do solemnly swear that the testimony you may give in the cause now pending before this court should be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Please have a seat on the witness stand and state this way. Your first and last name is correct.
Stephen, S-T-E-P-H-E-N, Oppler, O-P-P-L-E-R.
All right, Mr. Opler, would you pull the microphone closer, please?
Closer.
Thank you.
Mr. Opler, can you tell us what you do for a living?
I'm a senior investigator for the District Attorney's Office.
Okay, would you pull that mic a little closer so we can hear you?
Want me to repeat it? Do you need me to
I think
repeat it?
everybody heard that.
Okay.
All right. Sir, directing your attention to the date of July 27th, 1995, on that date, did you conduct an interview of a person by the name of Thano Paradas?
Yeah, actually, District Attorney, Deputy District Attorney Hank Goldberg, that I was with him, assisting him.
You were present?
Yes.
And was that interview videotaped in your presence, sir?
Yes, it was.
Now, do you know where did this take place, this videotape?
At his home,
Mr. Paradas' home?
Mr. Paredes' home.
And why was it done there?
It was my understanding that he had just had an operation concerning his heart. I don't know the specifics of it, but he had a heart operation.
So you were there at his home taping due to a medical condition of his?
Right.
Now, was was there any rehearsal prior to beginning the videotaping of that interview?
No.
Or
No, none.
In other words, as soon as you got there, the questioning began and the videotape started running?
Sustained.
I'm sorry. It is. When you began did you begin questioning at the same time you began videotaping?
Yes.
So the interview, would you characterize it as spontaneous?
Yes.
Yes, answer stricken.
How would you characterize the interview, sir?
Spontaneous.
What a coincidence. Let me ask you something else, sir. With respect to this tape, did Mr. Paradas explain to you over the course of the tape something that caused him to re-examine his testimony given at the preliminary hearing in the grand jury?
Objection, Your Honor. It speaks for itself.
That objection's overruled.
It's hearsay also.
Sustained.
Can you repeat it?
Sustained.
Oh, I'm sorry.
Sir, were you present during a hearing just now that took place in the court?
For most of it.
And did you hear the defense request the excision or...
Sustained. Sustained. That's not appropriate.
Was Mr. Paradas asked any question by Mr. Goldberg concerning what prompted him to to reevaluate his testimony at the preliminary hearing?
Objection, hearsay.
Sustained.
Question?
Sustained.
Do you recall the subject matter of what prompted Mr. Paradas' review of his preliminary hearing
Objection,
testimony
hearsay.
coming up?
Sustained.
Sir, have you observed the videotape that's about to be shown to the jury?
Yes, I have.
Okay, and has that videotape been edited at the court's request?
Objection, Your Honor.
Sustained.
Does that videotape contain everything that was conducted, every part of the interview that was conducted on July 27th, 1995?
No.
Thank you. I'm going to show you a portion of the beginning of that tape and ask you to identify it, indicate whether or not that is the taping that you recall being conducted in your presence on July 27th, 1995 of Thano Paratus.
Okay.
Photographer Teresa Ramirez, and this is going to be a videotaped interview of Thano, Thano Paratus, P-E-R-A-T-I-S, which is July 27, 1995, and the time now is approximately 3:48 p.m. Again, this is just a backup tape for the videotape that we're going to be taking. Okay, tape reads on the video 336.
Basically, what I wanted to do is...
Okay. You've seen that, Mr. Opler?
Yes, I have.
Do you recognize the voice that introduces the video?
Yes, that's mine.
And the person that is shown on the videotape, who is that?
That's Mr. Paratus.
And do you know what his role is in this case?
As I understand it, he took the blood. He withdrew the blood from Mr. Simpson for testing purposes.
And the other voice that you heard just before the tape was stopped. Do you recognize that voice?
Deputy District Attorney Hank Goldberg.
Was that the videotape that was conducted, videotaped interview that was conducted in your presence on July 27th, 1995 of Thano Paratus?
Yes.
Statements that you made at the preliminary hearing, and we'll go through those one at a time. And the reason for the videotaping, as I said before, is because there was a certain demonstration that you had wanted to show us. We thought it would be better if we had a videotape than if we just did it with an audio tape or something. And if you want to stop at any time or you feel uncomfortable, for any reason, just let us know. And I know that you've just been through a traumatic incident in terms of your health condition. The first thing that I wanted to know about was the statement in the preliminary hearing to the effect of when you were asked how much blood did you withdraw from Mr. Simpson, where you said approximately 8 cc's.
Yeah, that was an estimation, because that's what we all think we draw at that time.
When you say we, you mean?
The nurses.
And when you say that you think that you usually draw 8 cc's, that's based upon what?
Based upon what the vat container tube pulls out of the yarn.
Do you regularly measure how much you've drawn from a person after you've drawn the blood?
No.
Have you ever done it on any previous occasion prior to when Mr. Simpson came in?
Oh, I draw blood quite often, but not this sort.
But you don't measure it?
No, we never measure any blood.
And when you said not this sort, what do you mean by that?
Well, usually I draw blood for people that are arrested drug trafficking.
Okay.
And that's a different tube and different method. And just draw it and that's give it to the officer and that's it.
So was there something about this statement that I just mentioned to you where you were asked this question, how much blood did you withdraw from Mr. Simpson? You said approximately 8 cc's. And then you went on and you were asked, when you say approximately, did you not measure the amount? You said, well, it could have been 7.9 or it could have been 8.1. At some point, did you realize that that wasn't correct?
Not that day. I started measuring 1 cc and was scored in the test tube, and I kept doing it until I got 8 cc's. When I saw how much 8 cc's...
Excuse me, Mr. Opler. After Mr. Paratus said not that day, did he go on to give some further explanation of that topic?
Objection, Your Honor.
Oh. Yes, he did.
And was that previously on the tape?
Yes, it was.
That was more than I drew. So I took another test tube and kept putting in water until it looked approximately as to what I had drawn. I measured that, and that was about 6.5 cc's. So I estimated that's what I really had drawn. That's approximately 8 cc's right there. That was more than I drew.
And how did you know that?
Because it looks like it was more than I drew. So what I drew was approximately down to this point. There you go. Which should be 6.5 cc's.
So, after you've done this, what conclusion did you come to?
I came to the conclusion that I was wrong in the statement I made, that I could draw 8 cc's, that I could do about 6 to 6.5.
Is that an approximation?
That's still an approximation.
Yeah. There was another statement that I wanted to ask you about that also took place at the preliminary hearing. Let me just get hold of that. And that was the statement that said, I just looked at the syringe and it looked at about 8 cc's.
That was
Remember
a
that?
statement, which I agreed me. I looked at it, I should have said it looked like it was enough, which it was enough. 8 cc's, I was wrong in that 8 cc's altogether.
Can you show us what you did do in terms of looking at the syringe after the blood, or when the blood was being drugged? Mr. Simpson.
Syringe here. Okay, the blood was further out. I pulled it out. I saw that what it was. I squirted the blood into it. Trash. I just looked at the syringe.
Okay.
I didn't turn it over.
There is a part of the syringe that was calibrated.
Yeah, but I didn't, we just, unless you have a reason to look at those calibrations for dosage purposes, we just don't do it. I don't know how many nurses do. I've asked nurses, hey, do you know exactly how much blood you've drawn? No, about 8 cc's. Now, you want to make a bet and we'll check next time? Nobody wants to take the bet, take me on that bet.
So where did the figure 7.9, it could have been 7.9 or it could have been 8.1 come from?
It was an approximation. Even what I did here, okay, 6.5, but it could be 6.4, it could be 6.6. You can't, this is not exact. None of this stuff is exact. If you have an order exactly, then you're very careful. We don't have any special orders of how much you draw. If somebody should request a certain amount of blood, then I would be extremely careful to draw that much. So far, I never had a request like that.
Take blood with a syringe, a hypodermic syringe like that?
Most of the time we use them, I myself, most of the time I use the vacuum cleaner. But when I get someone...
It appears the monitor is flickering in the jury box. All of the monitors are flickering.
All right, Mr. Orlon, apparently everything but the big screen is jumping.
I think it has to do with the quality of the tape. The digitized video seems to make more sense than the direct video.
All right, juror number 1, juror number 7 and 8, is that watchable for you? All right, would any of you, those of you who are watching the small monitor in the front, want to take seats further in the jury box so you can see the big screen, or do you want to stay where you are? All right, let's proceed. Thank you, Ms. Clark.
I myself, I can control it better when I use a syringe. It's like, you just go in, I can see the people, give my...
Excuse me, Your Honor, it jumped a little bit. We're going to rewind so we can begin. I think it skipped some.
Other times, I can do a lot better. When I use a syringe.
Go ahead.
You just go in, you expect to be able to get my finger on that vein and go bang without a problem. Other times, I can do a lot better just by using the other eye. You, for example, without a tourniquet, I could just go bing on you.
Yeah, there's some things there.
Now, when you say that you usually use the vacutainer, what's that?
The vacutainer is, this is the vacutainer.
Oh, okay.
And what you do, you put a, I don't have one of those now, but you put it has a needle on this end too. You screw it in here. Then you put this in here, and you inject into the, and then when you're in the vein, you push on this, and it just sucks the blood through.
And that's based on the vacuum that's in the tube.
Yeah, on this now, nothing would happen because if there were any air in there, it would just suck it out, that's all. But this is made for a different type of thing. It usually has a needle on the other end. You just inject the needle.
How often do you use a syringe as opposed to a vacutainer?
Oh, not very often. It's just when I get a big person. And like I make an evaluation of the arm, and that's you get in the habit to do it right away. You look at the other attacker, I look at him, I have no trouble. If he came in for anything, I'd immediately go for a vein right like that. I saw his arms and they had veins like that. Oh, these never hurt here. And I just go out there bing bang with anything on him because those are nice big veins. I used to have those in Soy. And ruined on this side. When you get some of that with OJ is I'm pretty big. I've had other big people like that. And I usually just find it's a little easier, not only for me, but for the patient. You don't have to dig around. You hit them and that's it. And I haven't had any complaints of an ouch or anything.
Did you have any problems when you were drawing blood from the defendant?
I just, at this one certain point, as I was pulling, the bevel of the needle hit the wall of the vein, and that's when it stopped. And so you turn your syringe and draw more. But at this point, it appeared like I had enough. So that was it. I just stopped it.
Is that when you looked at the syringe at that point where the needle hit the wall?
Well, the needle hit the wall. It's the only reason it stopped. It was the reason the blood would stop. And I figured, well, that's enough. In fact, every time I draw blood and I reach that point, it just, well, you've got it, but there's no point in going any further. You can turn your needle and continue drawing, but there's a slightest, in my opinion, there's the slightest chance that you may damage the wall. I don't want to take that chance.
But when in relationship to the blood stopping, was it that you looked at the syringe?
Immediately.
Oh, that was when it was? But you looked at the part that's opposite from
Yeah, I did calibrations were on the bottom.
Okay. All right.
Because again, that's not what we go by.
You're going by what?
No, we just go, it seems like you go by instinct. But I've never had a case where we've never had enough blood.
You know, where they came back and said you didn't want blood.
Yeah, I've never had a case where it says we need more. I don't know any case, and if there has been, I don't know any, in our department, I don't know anything about it.
Okay. I think that's about it, unless you have something else you want to ask me.
Mr. Oppler, The entire tape, that is not the edited version that you see here, but the entire tape was given over to the defense, correct?
Yes, as far as I know.
And when Mr. Paradas referred to, I could just go bing on you, I don't need a tourniquet, who was he referring to?
He was referring to me.
Were you wearing short sleeves that day?
Yes.
I have one request of the court, if I could make it at sidebar.
All right, thank you, counsel. Ladies and gentlemen, if you recollect, I indicated to you that the tape that you just saw was to be used by you for the limited purpose of evaluating the credibility of Mr. Paradas, whose testimony you saw previously. Also, there was some editing that was apparent in the videotape, and you should know that that editing was done at the court's order. All right, Ms. Clark, do you have anything further for Mr. Offler?
No, thank you.
All right. You have any questions for Mr. Offler?
I do.
Right.
Thank you. Good afternoon, ladies and gentlemen. Mr. Oppler, is it Oppler?
Yes.
Okay, thank you. Mr. Oppler, how many years have you worked for the district attorney?
November will be 7.
7 years?
Yes.
Okay. As an investigator?
Yes.
Did you prepare any notes or reports in connection with this taping that occurred on July 27th of this summer?
Yes, there was a small report.
Do you have a copy of it with you?
I have it in my file upstairs.
May we have a sidebar, Your Honor?
All right, ladies and gentlemen, we're going to take a brief recess just to secure a copy of that report. Should only take about 5 or 10 minutes. Let me ask you to step back into the jury room. Mr. Oppler, go upstairs, get your report. All right.
Possible, I mean, the jurors may, can I have a 3-minute rest break? Or 2 minutes? Yeah, that's really.
Can I copy?
No, is it okay if you see it?
Well, after you handed it over, I assumed you knew what it was.
Oh, save time,
We just have a 4 minute break?
Well, we're going to take a break at 3. Can it wait till 3?
Sure.
All right. I mean, I'd like to finish, if at all possible.
My understanding that I will edit the brief portions I intend to use on our SIR rebuttal. I have to take our original back to do that. So I just want the witness to be on recall for the 5 minutes or whatever it'll take to recall on either Friday morning when we begin our SIR rebuttal case or Monday. That's the only way I can proceed because I don't have an edited version of those segments.
I assume the prosecution will finish either Friday or Monday.
Right, I'm just saying that that's...
No. All right, no, Mr. Oppler will be available.
Thank you.
All right. Sorted.
If we can resolve the Dutton issue tomorrow, we can rest tomorrow. I don't want to go to Friday. I'd like to rest tomorrow.
Was that what she said?
She indicated that people want to rest tomorrow after Diedrich and whatever is all.
I would think you can solve the Dutton issue very, very, very easily. I will step out and call Dean Oldham. If they promise to rest, I'll ask them to come down here tomorrow.
Well, I can't promise there's cross-examinations, Mr. Scheck. I mean, I don't know. We've got 2 witnesses.
Well,
I don't
Or are
think
they
let's-
yes?
Thank you, ladies and gentlemen. Let the record reflect that we've been rejoined by all the members of our jury panel. We found the report. Mr. Neufeld.
Thank you. Sorry about that. Mr. Oppler, you said you've been with the district attorney's office as an investigator about 7 years,
Yes,
and this investigation you went out on July 27th of 1995, that was at the request of Deputy District Attorney Hank Goldberg,
through my lieutenant, yes.
and did you actually set up the appointment with Mr. Paradas?
No, I didn't.
When were you first notified that you were going to be going to Mr. Paradis's on July 27th?
Earlier in that day.
And have you been working on this case, sir,
Yes,
since the beginning?
since October of last year.
So you knew when you went out to Mr. Paradis's house this past July 27th that Mr. Paradis had given sworn testimony to a grand jury in this case. Is that correct?
I was informed of that.
Okay. And you knew when you went out on July 27th that Mr. Paradis had also given sworn testimony as a witness called by the prosecutor, Marcia Clark, at a preliminary hearing on July 7th of 1994. Did you know that too?
I understood that, yes.
Okay. And you were told when you went out on July 27th to Mr. Paradis's home of this year, 1995, that the purpose of this taping was to obtain statements which would impeach or contradict the sworn testimony that Mr. Paradis gave approximately 1 year ago. You knew that too, didn't you?
I don't know so much in those terms. What I was informed of was that he conducted a demonstration to himself.
Sir, I'm asking you whether or not you were told when you went out there on July 27th that the purpose of this taped interview was to secure a statement from Mr. Paradis which would be used to impeach his own sworn testimony that he gave on July 7th of 1994 and June 22nd of 1994. Were you told that? I'm sorry, not were you told that, did you know that?
Objection, argumentative, hearsay.
Sustained.
Now, did you know when you went out there on July 27th of 1994 that this taping was being conducted because a determination had been made that Mr. Paradas was unavailable to come into court and be sworn in as a witness because of his poor health?
Yes.
And you knew when you went out there on July 27th to conduct this taped examination, or interview, I should say, of Mr. Paradas, that he wasn't going to be sworn in before he gave the statement to you. Isn't that correct?
I was never told he was going to be sworn in. No.
Okay. And you knew that because this interview was going to be conducted at Mr. Paradas' home, he was never going to be subjected to cross-examination, as he had been at the preliminary hearing when he was called by Marcia Clark.
Objection, irrelevant, calls for speculation.
Sustained.
Well, Mr. Oppler, did you make any effort on July 27th before you went out to Mr. Paradas' home to notify the defense so they could have a lawyer present for this interview?
No.
Objection, objection,
Overruled.
Seems legal fast.
Overruled.
Did you, sir, make any effort on July 27th to notify the defense so at least the defense investigator could be present?
No.
Objection, irrelevant.
Overruled.
And finally, sir, did you make any effort on July 27th to ensure that some independent person who was neither associated with the prosecution nor the defense could be present for this taped examination at Mr. Paradas' home?
Sustained. That's irrelevant.
What time did you arrive at Mr. Paradas' that day?
Approximately 3:15, 3:20.
And when you arrived at Mr. Paradas' home, did he let you in?
Yes.
And was he alone or with someone?
He was alone.
And where did he take you when he let you in, sir?
Originally, we went into the room adjacent to the entry, which I think was the living room, and we ended up upstairs in a room that was more like a den.
And how long did you stay in the living room before you went upstairs to the den?
Just a few minutes.
And who made the decision to go upstairs instead of doing it downstairs?
I believe it was Mr. Paradas said it would be more comfortable up there.
And sir, you said you arrived sometime between 3:15 and 3:20?
Approximately.
Now, according to the tape, the tape itself shows, I believe, one time, but you hear a voice over on the tape saying it's a different time. Is that correct?
That's correct. I was, when I initially put the heading on the tape, I stated 3:48, when in fact my watch was 3:38. The photographer said the tape on the video was 3:36. I checked my watch, it was 3:38, not 48. I was in error when I first said that. And on my backup audio cassette, which I was making, I believe I corrected that at the end of it.
So if you arrived between 3:15 and 3:20, and the taping began at approximately 3:38, that would mean that there was about 20 minutes while you were there at Mr. Paradas' home before you started rolling the tape. Isn't that correct?
When I say 3:15, 3:20, because we have radio and radio codes, that's when I called into the office. Then we walked to the house. We got there a minute or so later, and then and at that point we were downstairs, then went upstairs.
So, Mr. Oppler, am I correct in saying that it's approximately 15 minutes that you were there at Mr. Paradas' house before the tape began rolling?
Yes.
And it's your testimony that during that 15 minutes, other than saying, let's move upstairs so we'll be more comfortable. There was absolutely no discussion between Deputy District Attorney Hank Goldberg and Mr. Paradas.
There was no discussion regarding what the content of the tape would be.
You remember that specifically, sir?
I remember we weren't going to discuss that.
Now, during those 15 minutes before the tape started rolling, did Mr. Goldberg assure Mr. Paradas that he could say whatever he wanted to say because he wouldn't be sworn?
Sustained.
During the 15 minutes, by the way, we noticed that Mr. Paradas was holding a syringe at one point on the tape and holding a vacutainer. Did you and Mr. Goldberg bring that equipment with you to his house?
No.
He had it there already?
Yes.
He had it sitting out when you arrived?
I don't recall where it was when we arrived.
Now, sir, you said that that on direct examination that he was not rehearsed while you were there on July 27th. Is that correct?
Yes.
But during the course of this interview at Mr. Paradas' house, didn't Mr. Goldberg refer to other conversations and discussions that he had had with Mr. Paradas?
I don't recall. I'd have to see that tape again, that part of it where it said that. I don't recall every piece of that tape if he had that discussion.
To the best of your recollection, Mr. Goldberg never said during the course of the tape or bring up the fact that he had had any prior discussions with Mr. Paradas before just showing up on July 27th out of the blue?
I didn't say he never said it. I said I don't recall if he said that.
And you learned, sir, during the course of this examination, or your participation in this outing on July 27th, that Mr. Paradas had been an employee of the Los Angeles Police Department for some 30 or 40 years, did you not?
I didn't know the exact number of years. I knew it was many years.
And sir, you also learned during this outing on July 27th that the first time Mr. Paradas ever believed that his testimony, his sworn testimony, was false was after this trial actually began. Did you learn that on July 27th?
Yes.
And did you learn...
Overruled, late.
And did you learn on July 27th... One moment. That it was only after he learned that it was the defense theory through opening statements.
Calling for a conclusion on the part of this witness. This is somebody else. Sustained.
During this interview with Mr. Paradas at his home, did he show you the syringe or an exact replica of the syringe that was actually used to draw blood out of Mr. Simpson's on July 13th, 1994? I'm sorry, June 13th, 1994?
Objection to foundation.
Overruled.
He showed us a syringe that said it was like the one that he used. I don't know if the exact replica was it, but...
And in the syringe that he showed you, that he said was like the one that he used, didn't it have calibrations on the syringe itself with numbers so that anyone who looked at the syringe and saw liquid in it would know how much was there?
The syringe had calibrations on it.
And when we say calibrations, it had numbers indicating whether it was 1 cc, 2 cc's, 6 cc's, or 8 cc's, didn't it?
I didn't see it up close whether it said cc's or milliliters or what was the exact markings, but it was calibrated.
And it was calibrated with numbers
Right.
indicating quantities.
Right.
And it was calibrated with lines next to the numbers, so you could see where the liquid was at a certain point, couldn't you?
Correct.
And it was at that point that Mr. Paranis, during this interview, told you and the Deputy District Attorney, Hank Goldberg,
Sustained.
there was a time when we looked at the videotape where the image was jiggling a little bit. Have you seen a version of that tape where the image doesn't jiggle at all?
Yes.
And I noticed that when Mr. Paranis is giving an explanation of what he did when he looked at the syringe, when trying to explain his preliminary hearing testimony in which he...
Sustained. Phrase the question.
Do you remember the portion in the tape where Mr. Goldberg brings out the fact that Mr. Paranis had testified under oath that the amount in the syringe, the amount drawn could have been 7.9 or it could have been 8.1. I just looked at the syringe and it looked at about 8 cc's, unquote. Do you remember when Mr. Goldberg brought that point up to Mr. Paranis?
Yes.
Overruled.
And do you remember when Mr. Paranis showed you the syringe with the calibrations, the numbers and lines on it to indicate how much liquid would be in a syringe? Do you recall that?
Yes.
And do you recall that on this tape, he says, or I'm sorry, he then turns the syringe over so you can't see the numbers and calibrations, you only see a portion of the syringe that has no numbers on it. Do you recall that?
Yes.
Sir, is it your testimony that neither you, no, I'm sorry, that Deputy District Attorney Mr. Goldberg had no discussion at all with Mr. Paranis about how he held the syringe 12 months ago on June 13th before he uttered that description during that videotape session last month?
Are you speaking before we filmed the tape, or I'm not sure I understand the question.
Before you filmed the tape that day, on that day. That's the time frame I'm talking about.
Right, before the filming of the tape is what you're saying.
Yes. Do you understand the question? I can rephrase it if you like.
I'd like you to, please.
Sure. Prior to Mr. Paranis turning that syringe over, so he said that the numbers and calibrations couldn't be seen when he withdrew the syringe. What I'm asking is, did that subject come up at any time at all in the discussion between Deputy District Attorney Hank Goldberg and Mr. Paranis before he gave that statement on the videotape that day?
No.
There was no demonstration by Mr. Paranis off camera before the taping started of how he may have held the syringe?
Not in my presence.
Was there any mention in your presence of a concern that he had testified under oath that I just looked at the syringe and it looked at about 8 cc's? Was there any discussion at all that that would be a problem for the prosecution?
No.
Sir, at any point at all during that day, was there any substantive discussion held about this case when the tape was not running?
No.
So your testimony that the tape ran continuously and there was no time when the tape was turned off and discussion about the substantive facts of this case occurred?
No, the only downtime when we got there was when the photographer was setting up her equipment.
Mr. Oppler, isn't it a fact that according to the clock on the tape, on the original tape that you provided to the defense in this case, that the tape stops at 3:59 p.m. and resumes at 4:13 p.m. with approximately 14 minutes of downtime in between? Isn't that correct, sir?
Objection. Objection, Your Honor. Assumes facts not in evidence.
Overruled.
Hearsay, irrelevant.
Overruled.
352, misleading.
Can you repeat that, please?
Isn't it a fact that when you went to Mr. Paranis' home to make this tape and to interview Mr. Paranis, that the tape was turned off at 3:59 and resumed at 4:13, some 14 minutes later.
I don't recall that specifically. I think that there might have been a time that the photographer was checking and making sure that it was recording correctly.
Well, sir, you testified that the time that the tape began was approximately 3:36, is that right?
Approximately.
Well, if the tape was turned off at 3:59, that would be 23 minutes after the tape started, is that correct, sir?
Yes.
And if the tape was turned off at 3:59 and resumed at 4:13, some 14 minutes later, that certainly wouldn't be for the purpose of making sure the tape was working, would it, sir?
Probably not. I do recall her doing that. That may have been at the end just to make sure that the tape recorded before we left. So at that time, possibly that wasn't the reason.
Sir, other than the fact that the tape was working, is it your testimony that there was no that there was no break in this tape of some 14 minutes before you resumed this witness describing his position regarding his handling of the evidence in this case? Is that your testimony?
I don't recall the reason that the tape stopped. Other than being on tape, there was nothing substantive spoken about.
Sir, are you changing your testimony when you said a moment ago? One moment. Your Honor, I just need to get a little portion of the tape queued up. Sir, while he's queuing that up, let me ask you one other question. Was there ever a time during this interview on tape where Mr. Paradas, instead of actually speaking, mouthed words, "I don't remember"?
I do recall him mouthing words. I don't remember if it was I don't remember.
Well, if it had been him mouthing words, "I don't remember," but not saying that, would that be in response to his inability to remember that portion of the script that was given to him?
No.
Sustained. Answer stricken. Question and answer is stricken.
Well, sir, if in fact he mouthed the words, "I don't remember," are you sure that that would not be in response to something that had been discussed with him before the tape ran?
I'm positive. We didn't discuss anything concerning what we would be filming.
Are you as positive about the fact that you didn't discuss the substance of his testimony before the substance of his interview, of his unsworn interview, before the tape began running, as you are that there was no 14-minute break in the tape in which, after that break ended, you resumed the substantive discussion of the facts of this case?
Objection. That the statement of testimony is
Sustained.
recommended.
Sorry, Your Honor, we're just queuing it up, and it's my fault.
We'll take our recess at this point. I'm going to take our recess at this point. All right, ladies and gentlemen, we're going to take our mid-afternoon recess. Remember all my admonitions to you. Mr. Opler, you may step down. You're order to come back in 15 minutes, all right? 15. All right, let's have the jury, please. All right, thank you, ladies and gentlemen. Please be seated. All right, let the record reflect that we've been rejoined by all the members of our jury panel. Mr. Stephen Opler is on the witness stand undergoing cross-examination by Mr. Neufeld. Mr. Neufeld, you may conclude your cross-examination.
Thank you very much. Mr. Opler, do you consider yourself objective and fair?
Yes.
Or will.
When we just took this 15-minute recess, sir, did I...
35.
Okay. When we just took this 35-minute recess, sir, did I approach you when you came down to the stand and ask if I could speak to you for a few minutes alone?
Yes.
And did you at that time refuse to speak with me alone and instead state that you would only speak with me if the prosecutor, Ms. Clark, was present?
I stated I would be more comfortable.
Well, then I asked you after that, sir, if you would speak with me alone, notwithstanding the fact that you would be more comfortable to have Ms. Clark there, did you then say, I will not speak with you alone unless Ms. Clark is present?
After about 4 or 5 times when you kept saying, are you saying, will you not speak to me? I said, I would prefer Ms. Clark be there.
And after you kept saying that 3 or 4 times, sir, did you then say by that preference that you would be unwilling to sort of just walk over to the other side of the room with me alone and speak with me?
Yes.
Isn't that what happened?
That's what happened.
And, sir, is that because you felt as a witness it's important to have both sides present when I interview you?
I don't know specifically what I thought. I was in the middle of you questioning me, and to do it off the stand, I did not feel comfortable.
Well, let me ask you this. Did you think that it would be the better practice, sir, that when you went out to Mr. Paradis to have someone from the other side present as well?
Sustained.
Now, even after Ms. Clark came over, and the 3 of us stood over in the well there during the break, recall me asking you a question off the record over there in front of Ms. Clark, whether or not after all the taping was done for the day, whether Mr. Paradas said anything to you at all about the substance of this case. Do you recall me asking you that?
Something to that effect.
And do you recall, sir, that when I asked you that, even in front of Prosecutor Ms. Clark, that you said you wouldn't answer me there? Recall that, sir?
That was at the point where I just said that I would feel more comfortable. I'm sorry, excuse me. I did not feel comfortable in what we were doing, and I said I would answer anything under oath.
And did you say, sir, that you wouldn't even answer my simple question over there with Ms. Clark present?
Sustained.
Isn't it a fact, sir, that you then refused to talk to me at all about the substance of this case, even with Ms. Clark present during the recess?
Yeah, at that point, I really wasn't feeling comfortable. You kept repeating the same thing, and then I decided that it didn't feel appropriate to me.
Okay. But then, after I walked away, you did have a conversation, of course, with Ms. Clark and with Mr. Darden, didn't you?
I spoke to them.
Now, would you consider yourself fair and objective? Is that true, sir?
Absolutely.
Oh, I think we need to mark this segment as an exhibit, Your Honor.
How do you propose to capture it? You're going to provide us with a separate video of this
I will-
segment?
Yes.
Mrs. Robertson, defense 1376.
You notice it's 3:59 on the clock?
Yes.
Well, you're welcome.
Put you back?
I'm going to conclude my audio tape.
Okay.
I'm going to inject this 12 cc's into this syringe. Pull out some of the air.
Is that Mr. Goldberg's voice in the background, sir?
Yeah, I believe it was.
This syringe now has 12 cc's of water in it.
Thank you. You can stop. Sir, did you notice the clock?
Yes.
Did you notice that the tape stopped at 3:29 p.m.? 3:50, sorry, 3:59 p.m. Did you notice that, sir?
Yes.
And did you notice that the tape resumed at 4:13 p.m.?
Yes.
So there was 14 minutes when the tape was not playing. Is that correct, sir?
Yes.
Now, is it your testimony that just all of a sudden, after 14 minutes of no taping, that the tape was simply turned on and Mr. Paradas is sitting there with the syringe and the vial?
Objection, you state the testimony.
Sustained.
Didn't you testify, sir, earlier on cross-examination that there was no substantive discussion at all unless the tape was running?
I believe I said that. After seeing that and recalling, after we stopped the tape, I don't recall specifically if it was Mr. Paradas saying he wanted to show us something or if it was Mr. Goldberg saying that there was something he forgot to mention, but we went back on the tape. Teresa, the photographer, had been packing up and then reset it up, and we went back on the tape.
Is it your testimony, sir, that during the 14 minutes after the first portion of the tape ended, that all that was said was, oh, there was something I forgot to bring up, or Mr. Goldberg said, oh, there was another question I wanted to ask you? Is that what you're now saying, sir?
That, to the best of my recollection, that's what happened.
And during the break, sir, did you see this portion of the tape during this 35-minute recess we just took?
No.
Sir, were you standing in this courtroom when Mr. Harris played the tape with you standing here and Ms. Clark standing right here?
Ms. Clark said she wanted to see it. I was standing there, but I was not watching the monitor.
It's your testimony, sir, that you were standing here during the break and the tape was playing and the audio was playing, but you didn't watch it at all?
It was
Is
on.
that your testimony,
It was
sir?
on. I noticed it was on. I spoke to a lot of people during the break, and I think that might have even been the time that Ms. Martinez was in here. I was speaking to Mr. Darden, Ms. Clark. It was on. I recall Ms. Clark saying that she wanted to see it on that screen. I was not watching it at that point.
Mr. Opler, the last series of questions before we broke for the recess dealt with your failure to acknowledge that there was a 14-minute gap between the first portion of the tap. Okay. You recall that this subject of the tape being turned off for several minutes, 14 minutes, and then being turned on again, was the last thing we were talking about before the break. Do you recall that?
Yes.
And it's your testimony now that when I finally, during that 35-minute recess, played the segment that you just saw now, that you weren't watching, you weren't paying attention? Is that your testimony?
That's what I just said, yes.
Thank you. Nothing further.
Mr. Opler, when you came down to court today, what did you expect to be doing?
To introduce...
Sorry, I couldn't hear the question, Your Honor.
You have it right there in front of you, don't you?
No, I don't. I'm sorry.
When you
All right,
came
question-
down to
question
court
was,
today...
what was he expecting to testify to today?
Objection irrelevant.
Oh,
I was expecting to come here and introduce the videotape and basically be done.
Did you even expect to be cross-examined?
Maybe a question or two.
Objection, Your Honor, that's what his expectation.
overruled.
You indicated that there was a report you prepared. Have you seen that report, sir?
Yes.
What is it? What did you put into that report?
Oh, objection, Your Honor, that's the report.
Sustained.
Yes, sir.
I'd like to mark this report, Your Honor. People's next in order. You have it.
617. And counsel, I'm sorry, excuse me just a second. The videotape should be 1375, the people's, defense next exhibit. Ms. Clark.
Do you recognize that?
Yes, I do.
What is it?
It's a report I wrote on July 31st.
Does it contain anything about the substance of your interview, of the interview conducted by Hank Goldberg with Donald Paratus?
No.
What do you put into your report?
Objection, Your Honor.
Sustained.
What's the purpose of preparing that report, sir? Other than simply,
Objection, hearsay.
Finish the question.
was there anything substantive concerning the subject matter of the interview in that report, sir?
Objection, hearsay.
Overruled.
The only thing that I wrote of substance...
Objection is what he wrote.
No, the question, just answer the question. Yes or no, was there anything substantive?
Yes.
And what is that?
Objection, hearsay.
Sustained.
What is the purpose of that report, sir?
Asked and answered.
Overruled. Who wants to make the objections there?
Primarily just to document that I was there with DDA Goldberg and to...
No, I would object, 'cause the question was, what's the purpose of a report, not what was the purpose of this particular
Overruled.
report.
Overruled.
and to put into the record the numbers of the two tapes.
Numbers?
The sound lab, our sound lab, the District Attorney's Bureau of Investigation Sound Lab, gives an evidence number or their number to videotapes and audio tapes that we make.
Okay. And that's why you make a report, to document that?
That's why I did here, yes.
Now, you are aware, sir, are you not, that the defense has interviewed Donald Paratus?
Objection, Your Honor.
Overruled.
Yes.
And are you aware of exactly when that interview took place?
No, I'm not.
Are you aware that the interview occurred?
Objection, Your Honor. You already said he wasn't aware.
Sustained.
I asked exactly when the interview took place. You're not aware of when that interview took place?
No.
Were you aware whether it took place before or after this videotaped interview on July 27th?
I'm not aware of it.
So, other than the fact that you know the defense did talk to Mr. Paratus, you don't know when it was?
Right.
Did you ask any questions of Mr. Paradas during this interview, sir?
No, I don't believe so, other than when he was sticking the needle back in the cup, not to stick me with it when I was holding it. I think I requested that.
You were holding the cup that he put the needle back into?
When he was drawing water during a demonstration,
And then you were holding a cup for him?
yes.
When he put the needle back in, you asked him not to stick you with the needle?
I think something to the effect of be careful
All right.
not to stick me with the needle.
All right, other than that request, did you direct this interview, sir?
No,
Did you have anything to do with determining what the content of the questions would be by Mr. Goldberg?
no,
Did you ask that the tape be turned off at any particular point?
no,
Did you ask that the tape be turned on again at any particular point?
no.
What were you doing there, sir?
It was my understanding when I went out that it was just going to be to document that it happened. To document it happened, it was going to be a videotape. It was my belief that I was just, if need be, I was just going to introduce that here, and that it would speak for itself.
Do you expect to come here and be badgered like this by Mr. Neufeld?
Sustained.
All right, when Mr. Neufeld asked you questions during this half-hour break, sir, can you describe his demeanor
Hostile.
and the manner in which he asked you questions?
In the manner in which he kept repeating after I told him I preferred not to.
And why did you prefer not to, sir?
It just didn't feel comfortable. It didn't feel right to me to do it in the middle of my testimony.
Did you tell him under what conditions you would answer questions?
On the stand,
Under oath?
under oath, I said I'd be happy to answer anything.
Now, during the 14 minutes, can you tell us, first of all, the tape stopped at 3:59, correct?
Yes.
And after the tape stopped, what happened?
I don't recall if it was Mr. Paradas saying there was something that he still needed to demonstrate, or if it was Hank Goldberg, Didier Goldberg, remembering that he wanted him to demonstrate something, but there was something else that was going to be done. It was almost an afterthought, and then it was done. We were back on the tape, and they did it.
All right, now, before you were actually shown the segment where there was a stop and a start and a tape, did you have an independent recollection of that event, of it having been stopped and started?
No. It happened about the same time as I said that she tested to make sure that it taped before we left. Toward the end, he had a TV right there, and it was all within that same time frame.
Well, when this taping was going on, sir, was there some kind of equipment that she had set up, was it Ms. Ramirez,
Yes.
of the photo lab unit?
Yes.
And was there some equipment she had set up to conduct this videotaping?
Yes.
When the tape stopped at 3:59, did she proceed to dismantle that equipment?
Yes.
And when Mr. Goldberg or Mr. Paradas indicated they wanted to say something else, did she have to go there and set it back up again?
No objection, leading and asked and answered.
Rephrase the question.
When you indicated it was either Mr. Goldberg or Mr. Paradas that indicated a desire to say something further on the tape, correct?
Right.
At that point, had she begun to break the equipment down
Yes, I think so.
and pack up?
Yes.
Did you see her at some point play the tape on the television to see if it had taped correctly?
Yes.
And did that occur during the 14-minute break?
I don't recall if it was during that 14-minute break or afterwards. It could have been either. I can't say for sure.
Are you sure, however, that she began to pack up her equipment during that 14-minute break?
Yes.
Then when Mr. Goldberg and Mr. Paradas indicated a desire to tape some more discussion, what did she do?
Set it back up and film the rest of it, whatever remained.
Do you know, Mr. Paradas in that last segment was holding a 12cc syringe, correct?
Right.
Earlier in the interview, had he been showing anything with a 12cc syringe?
He hadn't shown us.
I believe that actually misstates what you saw on the tape, and misstates the testimony.
Sustained. There's no testimony in the record regarding the size of the syringe.
Can we play the tape, Your Honor?
Play the whole tape? Not at this point. Proceed with your examination. See if you can lay a foundation for what it was.
Okay. Do you recall, sir, at this moment, what was the substance of Mr. Paradas' statement at 4:13 on the tape?
What was the status of that last segment? Is that what you're asking me?
Do you recall independently now, without reviewing the videotape, what Mr. Paradas was showing on the videotape when it was resumed at 4:13?
It was a 12 cc container of some sort.
Okay. Now when the interview began at 3:36?
Yes.
Okay. When the interview began at 3:36 until it concluded at 3:59, had, to your recollection, he shown a 12 cc vial during that 23-minute segment?
He had a little box with different vials. I don't recall if that one was in there or not. I don't believe he demonstrated with that one, though.
Okay. During the 14 minutes after the tape stopped at 3:59, did he go to look for that 12 cc syringe, to your recollection?
Objection. That wasn't his testimony. That was a 12 cc syringe. It was some 12 cc container.
Container.
Rephrase the question.
Did he go to look for some 12 cc container?
There was a point that he went to look for another container, syringe, whatever it was, and then he came back. If this was that exact time, I don't recall. There was a time they left and he came back to get something. It wasn't, I remember him shuffling the box, it wasn't in there, and he went to get it. This could very well have been that time.
Objection. One strikes. He says it could have been. It calls for the speculating.
Overruled.
All right, sir, at any time did Mr. Goldberg suggest to Mr. Paradas what he was supposed to say?
No.
Did you ever suggest to him what he was supposed to say?
No.
Was Mr. Paradas given any kind of written material or script to look at before he answered questions on the videotape?
No.
Your water supply.
It's good. Thank you.
Mr. Oppler, it was the videographer who was taking apart and putting back the equipment, correct?
Yes.
It wasn't Mr. Goldberg, correct?
No.
And it wasn't Mr. Paradas, right?
Right.
So while she's taking apart her equipment, Mr. Paradas and Mr. Goldberg are free to have whatever discussions they want during that 14-minute period. Is that correct?
Yes.
And if Mr. Paradas happened to walk off for some period of time to get another syringe, that didn't take up 14 minutes, did it?
Objection, speculation.
Sustained.
Well,
Rephrase the question.
you said on redirect examination that you're not even sure if during those 14 minutes Mr. Paradas even went off to get another syringe, are you?
Correct.
And, sir, you also said at the end of her redirect examination a moment ago that that day when you arrived there was no script given to Mr. Paradas. Is that right?
Correct.
And no instructions before the tape began rolling the first time to Mr. Paradas. Is that correct?
Correct.
But you don't know to what extent Mr. Goldberg prepped him on prior occasions, do you?
No, I wouldn't.
Sustained.
Nothing further.
Ms. Clark?
Was there anything about the nature of Mr. Paradas' demeanor or his answers that led you to believe anyone had coached him, sir?
Your Honor, he's not qualified, man.
Sustained. Sustained.
Did you form any impression about Mr. Paradas', the nature of Mr. Paradas' responses to the question?
Objection, he's not competent to answer that either.
Say. All right. Anything else?
Nothing else.
All right, thank you. Mr. Rockler, thank you very much. You're excused, sir. Yes. All right, counsel, let me see you at the sidebar without the court reporter, please. Our next witness is elsewhere in the building, so I'm going to have that person brought down. As soon as they're here, we'll call you back out. So we'll take a couple minutes. Is witness available? All right, and who is that?
Teresa Ramirez.
All right, and she was the camera person?
That's right, Your Honor.
All right.
We had not anticipated calling her. I'm sure the court can understand why the people would like to call her at this point based on the nature of the cross-examination conducted of Mr. Oppler. She will testify to what transpired when the tape was turned off at 3:59 and when it was turned back on at 4:13.
The problem with that, Your Honor, is I think Mr. Neufeld, I thought when we approached the bench, well, there's no court reporter, but do you mind? Okay, when we said, she said, I thought when she said Teresa, I thought she meant Beverly D. Teresa. And this is Neufeld's witness, and so he's apparently somebody in the courtroom. I got to get him back, and we didn't understand this is who it would be. We thought it was the Stewart's person.
No.
So,
Mr. Shapiro, hold on.
okay.
Okay. Okay, back on the record in the Simpson matter. All parties are again present. Next witness is Teresa
Ramirez of
Ramirez.
the Photo Lab of the District Attorney's Office. She's in addition to our witness list that we made in view of the nature of the cross-examination of Mr. Oppler.
The only thing is we want to move the case along also, Your Honor. I misunderstood our sidebar. I thought it was Beverly D. Teresa, another witness which I have, and I was prepared on that. But what I'd like to do is an opportunity to get Mr. Neufeld, this is his witness, and also I'm sure he'll want to talk to her because she wasn't on the witness list, violates the 3-day rule. But we'll be ready to go, I'm sure.
All right, you need 5 minutes to talk to her?
I got to get Neufeld first, Your Honor. I might need a few more minutes than that, but we'll be ready.
All right, and Mr. Neufeld and the others are looking at the other physical evidence
As I
right
understand
now.
it, I've got to
Mr.
find out.
Fairtlow, would you see if you can find Mr. Neufeld, please?
Assuming that I can get the door open.
You're going to get the fire marshals after us. Again.
You can't get in there. That's right, Jen, that's right.
All right, we're going to have to fix that this evening.
Yeah, obviously. Maybe you should go around the other way. Come on this way.
How's the jury going to get in?
Yeah.
A little too much tape on the wire.
All right, then I will get off the bench, get Mr. Neufeld here, have him talk with Ms.
We want to take up the sanction issue. We have a lawyer here on the issue.
There are lots of lawyers here, Mr. Darden.
I understand that, but I don't know if you wanted to spend the time on the record on the sanction issue while you have...
Well, we might as well make good use of the time.
Your Honor, Brent Riggs from the DA's office.
Mr. Riggs, how are you? Good to see you.
I wonder if I might impose on the court to perhaps go in chambers with Ms. Clark and Mr. Darden for a few moments.
Why would that be necessary in chambers?
Well, we just think it might be appropriate to have a private conversation if the court wouldn't mind.
Well, I don't think that's appropriate.
Well, what we're doing, I suppose, is begging the court's indulgence for our failure to have an attorney here at 8:30 this morning. As the court probably is aware, we have asked the Court of Appeal to stay the fine, but in any event, we would ask the court to reconsider, at least if not the fine altogether, at least the amount. It does appear that Ms. Clark, in explaining the reason for the delay this morning, was being forthright with the court, and furthermore that she was engaging in diligent advocacy when she defended the office against the fine. So we would ask the court to at least reconsider the amount, if not the fine altogether.
All right, original fine will be reinstated. Anything else, Mr. Riggs?
No, that's all.
All right, thank you, sir. Good to see you.
$250.
Yes. But see, Mr. Riggs is short, to the point. This is what we want. This is why we want it. Thank you very much. Goodbye. Notice how effective that is? Persuasive. Okay, Mr. Neufeld, I'm going to get off the bench so that you can talk to the witness.
Well, actually, I'm going to ask that she be called tomorrow morning. I mean, first of all, there has been a rule. I'm asking for 3 days, but I'm
No.
asking for 12 hours.
No, right now. Talk to her.
Well, Your Honor, my concern is that we're doing the other things to prepare for Dietrich.
Will I chat with the next witness? All right. Deputy McNair, let's have the jurors, please. Ladies and gentlemen, have a seat, please. All right, Ms. Clark, you may call the people's next witness.
Thank you, Your Honor. People call Ms. Teresa Ramirez.
All right, Ms. Ramirez, come forward, please.
Raise your right hand, please. You do solemnly swear that the testimony you may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God. Please have a seat in the witness stand and state to spell your first and last names for the record.
Teresa, last name Ramirez.
Ms. Clark.
Thank you, Your Honor. Ms. Ramirez, can you tell us what you do for a living?
I'm a photographer for the Bureau of Investigation of Los Angeles County District Attorney's Office.
And you work in what we call the photo lab in the DA's office?
Yes,
Directing your attention to the date of July 27th, 1995, did you perform the videotaping of an interview of Thano Paradas?
yes,
And in order to do that, did you go to the home of Thano Paradas?
yes.
And who was with you?
Hank Goldberg?
You see a
And-
DA?
Yes,
You see him here in the courtroom?
yes,
Back there?
yes.
Okay. Who else?
Stephen Opler?
Was that a DA investigator?
Yes,
And is that somebody who testified in court today?
yes,
Did you see him testify on television today?
yes.
Did you watch all of his testimony?
Excuse me?
Did you watch all of his testimony?
No.
Okay. And who else was there? There was
Uh,
you, Steve Opler, Hank Goldberg, and...
Mr. Paradas? He lives there.
And did you perform the videotaping of the interview conducted by Hank Goldberg?
Yes,
At some point, did the interview stop?
yes,
And at some point thereafter, did the interview resume again?
yes.
In between the time that the interview stopped and it started, can you tell us what occurred?
I noticed that Mr. Paradas had a very nice television set, and I asked him if we could check the tape I just done, if we could watch it on his TV. And he agreed, but he had to go and change, I don't know, he rehook it up or something.
So did he go into another room at that point?
It was like a little, next to where I was standing, it was like a little bigger than a closet. He had a lot of tapes and cables. He went in there, took some cables, went behind the TV and the VCR and hooked it up.
And then did he do the actual hookup himself for you?
Yes.
Your Honor, I wonder if we could play Defense Exhibit 13.
1375. Mrs. Robertson, do you have 1375? All right.
I'm going to show you a segment of tape and ask if you recognize it, I think. You recognize this tape, Ms. Ramirez?
Yes.
All right. Is this the videotape you did of Thano Paradas in the company of Hank Goldberg and Steve Opler on July 27th, 1995?
Yes.
And did you operate the video camera?
Yes.
All right. Now, you see the time there? Is that, you see the time of 3:59 there?
Yes.
Okay. No, go ahead. Keep it running. Wait, can we back up for a minute? Just back up to 3:59. Thanks.
Okay. I'm going to conclude my audio
All right.
I'm going to eject this.
Okay, you saw that 3:59, and then you heard a voice. I'm going to conclude my audio tape.
Yes.
And whose voice was that?
Upler.
Okay. And then you saw the tape resume at 4:13?
Yes.
What happened in between 3:59 and when you resumed the tape at 4:13?
Mr. Parados hooked up his TV so we could watch the tape. We watched the tape I've just done for a minute or two, probably.
How long did it take for him to hook up the TV so you could watch the tape?
Few minutes, because first he checked that the TV was not hooked up properly, then he hooked it up, then he checked that it worked again, then we played the tape I did, and then Hank said that he had another question. So I had to cue the tape to the end, put the camera back on the tripod, put the tape back in there, and start again.
All right,
But
so, I'm sorry.
I missed, usually when we videotape somebody, the investigator that is conducting the interview at the DA says that we were off for a few minutes or whatever, and I missed that part on the videotape. So when the tape starts again, Mr. Parados is already answering to the question. So I probably missed, I don't know, up to a minute.
You started the tape a little late, is that
Yes.
right? And you missed the part where Mr. Oppler announced that you had been off tape for a while and you're resuming.
Yes.
And did you miss Mr. Goldberg's question?
Yes.
Is there anything else you missed?
No.
During the time that you were setting up, Mr. Parados was setting up the cable on the television so you could watch the tape, were you talking to him?
To who?
Mr.
Excuse me.
Parados.
I don't remember.
Was anyone questioning him?
Overruled.
No.
Was Mr. Goldberg interviewing him during the time the videotape was off?
No.
Did you discuss anything with Mr. Parados concerning the case?
No.
Did you make any remark to him about his equipment?
Yes.
What was that?
Sustained.
Not for the truth of the matter, Your Honor.
All right. Does this explain subsequent conduct with regards to the television equipment?
Yes.
All right, proceed.
I made a comment about his impressive television set, and he had more than one VCR, at least 4.
And so did that have some impact on the manner in which he was setting up the cables and connecting the TV to the cables?
Sustained. Leading.
I'm sorry. And why were you discussing that?
As part of my job, I'd work with VCRs and television sets and cameras, so I asked him to play the tape because I wanted to see how it worked.
Okay. Did his system appear complex to you?
Yes.
Was there more than one piece of equipment there?
Yes.
How many pieces of equipment did he have?
It was one television monitor, and I remember that there were at least 4 VCRs, plus some stereo equipment in speakers, receivers.
4 VCRs?
Yes.
So did you discuss that with him?
Overruled. You can answer the question.
I made a comment about his nice equipment. He said he didn't like to miss shows while he was at work.
Now, during the course of that conversation, was he attempting to do anything with respect to the cable, the television, and the VCRs?
Yes, he moved something in the back.
And who was in the room at that time?
Stephen Oppler and Hank Goldberg.
Was anybody asking him questions during that time?
I don't remember.
Was anybody interviewing him concerning the case at that time?
No.
Asked and answered.
Over.
Did he have any difficulty hooking up the TV to the correct VCR?
No, really.
Okay. And after he finished the hookup, what happened next?
We watched the tape.
And did you watch the entire tape?
No.
How much did you watch?
Overruled. Have we already gotten an answer
Have
to this
we?
question?
I'm sorry.
A minute or so?
Okay, thank you. And after you watched it for a minute or so, then what happened?
Objection. Asked and answered. Hold on, as they say.
Overruled.
I took the tape out of the machine,
And then what
and I
happened?
was starting to put it away as well as my camera and the rest of the equipment. But the DA said that he had another question. So then I had to put the tape back and cue it to the end. But I don't remember if I did it in the camera or on his VCR.
Okay.
But I had to do that. So that probably took another couple of minutes.
And then you indicated, I think before, that you had to set your camera back up again.
Yes,
Then, at that point, did you resume the taping of Mr. Paradas?
yes.
And I would like to show the segment, if I may, Defense 1375 again.
There's 12 cc.
All right. Well, thanks a lot.
Well, you're sure welcome.
Okay, I'm going to conclude my audio tape.
I'm going to inject this 12 cc's into this syringe. Pull out some here.
Mr. Clark, you need to show us anyone?
I wanted to show to the end if I could.
Yes, for the court clerk, please. All right, thank you, counsel. Ms. Clark, you wanted to play 1375 to its conclusion at this point?
Yes, Your Honor.
All right, let's proceed.
Thank you.
This syringe now has 12 cc's of water in it.
That was it?
That's it. Let me ask you, Ms. Ramirez, is that the segment that was taped after the 14-minute break?
Yes, but it looks like it didn't, like the end is missing, at least from this copy.
Okay. Do you know how long you went, for how long you videotaped after the 14-minute break?
No, I don't remember.
Do you remember if it was 1 minute versus half an hour? Was it a long time that you went?
Your Honor, it's leading to speculation. She said she doesn't remember.
Oral.
I remember that it was only one question, so it was very short. I can't tell how long.
So Hank Goldberg asked one question and Mr. Paradas gave that one answer?
Yes,
And that's all that happened?
yes.
Now, did Mr. Goldberg give us a set of questions or any written materials to Mr. Paradas during the questioning?
No,
And during the 14-minute break, did he hand Mr. Paradas any written materials or any kind of questions written down on paper?
no,
And did you do any other tape with Mr. Paradas besides this one?
no.
Was there a reason for that?
I don't know.
Did Mr. Goldberg convey to you any concern about Mr. Paradas?
No,
Did you discuss with anybody Mr. Paradas' physical condition?
I don't remember.
Do you remember whether you discussed Mr. Paradas' physical condition with Hank Goldberg?
I don't remember.
Now, today, did Mr. Darden and I go to your office and locate you?
Yes,
And was that at about 4 o'clock today?
I think so.
Where were you? Were you on your way to go somewhere?
I had a dentist appointment. Yes, I was
See-
leaving.
Had we ever contacted you and asked you to testify before 4 o'clock this afternoon?
No,
If we had gotten there at 4:05, would you have been gone to the dentist?
perhaps.
Have we, did we speak to you for about 10 minutes?
Sustained.
How long did we speak to you for? Mr. Darden and I up in your office, how long did we speak to you for?
It was short. I can't remember. I got really nervous when I saw you.
Why was that?
It's irrelevant for...
I like to be.
Well, hold on. Let's move on.
All right, I'm sorry. And after that, Ms. Ramirez, did we bring you down to the courtroom?
Yes,
And did you sit and speak with Mr. Neufeld and Mr. Cochran for about half an hour?
yes,
They ask you all the questions they wanted to ask?
yes,
And you answer all those questions?
yes.
I have nothing further.
Mr. Neufeld.
Just 1 second. Mr. Ramirez, hi, good afternoon.
Good afternoon.
You said you were on your way home when, or you were about to leave when you were contacted by Ms. Clark and Mr. Darden?
Yes,
And in fact, just before that, you'd been watching your colleague, Mr. Opler, testify, is that right?
part.
Okay. And it was while you were listening to Mr. Opler testifying that a supervisor of yours contacted you?
Yes,
And that would be a deputy district attorney named Ross?
she's an investigator.
Okay. An investigator named Ross?
Yes,
And she made some joking, critical comment of your taping?
yes,
And shortly after that, you were contacted by a deputy district attorney, Ms. Martinez, is that right?
yes,
And as a result of that, you then were spoken to by, after Ms. Martinez, by Ms. Clark and Mr. Darden, is that right?
yes,
The next thing you know, you're down here in the courtroom.
yes,
Okay. Now, back on that day, on the 27th, You remember Ms. Clark asking a few questions a while ago about whether or not Mr. Goldberg told you anything about Mr. Paradis' health. Do you recall Mr. Goldberg telling you that Mr. Paradis had just had a like a bypass or heart surgery this summer? Do you recall something like that? That he had just had heart surgery?
Yes, but I don't remember when it was said. He mentioned.
Okay. Now, by the way, just two other questions, or two other subjects, I'm sorry, Your Honor. During that 14 minutes when the tape wasn't playing, you said that Mr. Paradis got up and gave you a cable. Did he do that?
He didn't give me anything.
Did he stay in the room with you that whole time?
He went into a space that it looked like a big closet and got some cables and hooked up his TV.
And that closet was in the room that you were in?
Yes, it might be a small room.
But you could see what he was doing when he did
Yes,
this?
yes.
Okay. And other than that, he never left the room, did he?
No,
Never left the room to go get a syringe or anything, correct?
I don't remember that.
Overruled.
To the best of your recollection, he was in the room the whole time?
Yes.
One other matter. Now, although you said to the prosecutor that, to the best of your recollection, Mr. Goldberg did not hand Mr. Paradis any instructions that day, to your knowledge, did Mr. Goldberg...
Yes.
I thought that's what I just said. No.
No, did not hand. Yes. Restate the question.
Sure. Okay. I know that you said a little while ago that, as best you can recall, during that afternoon... By the way, during that 14-minute break, were you primarily concerned with packing and unpacking your equipment?
Well, we also watched the tape.
Well,
We
when
took
you
most
weren't-
of the,
I'm sorry, go ahead.
most of that time was taken by watching the tape and then re-cueing the tape, playing it back to the end.
Does your viewfinder have a playback so you can look through the viewfinder and see the tape?
Yes, but I think I wanted to see how that TV looked like.
But you couldn't simply see whether or not it's been taping by looking through the viewfinder?
Yes, but it's difficult for everybody else to see it. I mean, you cannot. Only one person can. So I thought it was better to just play it back on the big TV.
Right. Now, you had said that Mr. Goldberg did not give, to the best of your recollection, give Mr. Paradis any instructions that day when the tape wasn't playing. Is that right?
He did not.
But you don't know to what extent Mr. Goldberg had prior conversations with Mr. Paradis before he arrived that day. Isn't that correct?
We all came together.
Well, but you don't know whether or not prior to your arrival there that day, either earlier that day or the day before or some other day, Mr. Goldberg had conversations with Mr. Paradis where he explained to him what he wanted him to say the day that you arrived.
I don't know.
No, the way it's phrased, it's argumentative.
While you were there, didn't Mr. Goldberg say that he had, or didn't he refer to prior conversations he had had with Mr. Paradis prior to the time you got there on July 27th?
Confusing, vague.
Overruled. Do you understand the question?
It sounds like three questions.
Let me ask you this, Mr. Ramirez. Do you remember that day while you were there, Mr. Paradis holding up a subpoena? Do you remember that? Holding up a piece of paper on the tape?
Yes.
Because you've seen the tape several times, haven't
Yes.
you? In fact,
Yes.
you're the person who edited the tape?
356 and 352.
Overruled.
Can you repeat the
Are you
question?
the person who edited the tape?
Yes.
And ladies and gentlemen, you'll recollect, as I instructed you, the editing you saw in the tape was at my direction.
Yes.
All right.
And when Mr. Paradis held up that subpoena the day you were there on July 27th, he described the conversation he had with Mr. Goldberg back in February, didn't he? About that subpoena.
I don't remember the exact words.
Do you remember Mr. Paradas holding up a piece of paper and saying, "This is the subpoena that Mr. Goldberg gave me"?
Overruled. You can answer the question. Do you remember that?
I can only remember the piece of paper.
And do you remember him saying it was a subpoena for Mr. Paradas to come to court back in February? Do you remember that?
Hearsay, Your Honor.
Overruled.
Not the exact words.
If you saw that portion of the tape, would that refresh your recollection?
Yes.
May I have just a few minutes to do that, Your Honor? Just to cue up that portion?
Procedure to refresh the witness's recollection is to show it to the witness.
Perhaps she could step down and she could look at it with Mr. Harrison sitting over there.
Do you have headphones? All right, let's conclude this for the day. We're not going to finish. All right, ladies and gentlemen, we're going to take our recess for the afternoon session. Please remember all my admonitions to you. Don't discuss the case amongst yourselves. Don't form any opinions about the case. Don't conduct any deliberations until the matter has been submitted to you. Don't allow anybody to communicate with you with regard to the case. We'll stand in recess as far as the jury is concerned until 9 o'clock tomorrow morning. And Ms. Ramirez, you may step down your order to come back tomorrow morning at 9 o'clock. All right? Thank you.
Please play record.